the plaintiff in this matter, Kendra Harmsen. Ms. Harmsen, good morning to you.
Morning.
And next on my screen is Cameron Whitmore. Mr. Whitmore, good morning.
Morning.
And appearing on behalf of the people, Assistant Kent County Prosecuting Attorney Margaret Rummel. Ms. Rummel, good morning to you.
Good morning, Your Honor.
So if Ms. Rummel, if you would indulge me a second. A complaint for child support was filed on September 8 of this year. It was served on September 23rd of this year. The defendant, Mr. Whitmore, filed an answer on September 25 of this year. A pre-hearing was scheduled for October 21st of this year. The support as calculated by the prosecutor's office for two children is $1,121 in base support, $86 in a premium adjustment, for a total of $1,035 per month. The reservation of that date, or the commence date, is reserved when there's only one child subject to the calculus. The calculation is $752 in base support, 43 as a premium adjustment, $709 per month. Actual incomes were utilized for both parties based on 52 overnights per year. And the uninsured medical expense percentage is plaintiff 34%, the defendant being 66%, and Section 4D birth expenses were waived. However, applying the Michigan child support formula in this matter would be unjust and inappropriate, as the parties are not requesting involvement at this time relative to child support. So pursuant to Michigan Child Support Formula Manual 1.04 E as in Edward 18, the commence date will be reserved until such time as a request is received by the parties. Before I hear from them, Ms. Rummel, anything you want to add?
The reserved effective date was a clerical error on my point, or on my part. The effective date should be 10/1 of 2025. Again, that was just a clerical error. The plaintiff is requesting support. I had a pre-hearing and discussed these figures with the parties, as you stated. The plaintiff accepted the number, defendant did not. And I will let him place his objections on the record. Thank you.
Thank you. I'll turn to Ms. Harmsen first. Anything you want to add before I hear from Mr. Whitmore?
No.
Thank you. Mr. Whitmore, I'll give you the floor. What's your thoughts as far as the child support is concerned?
I have no issue providing support to my children financially. However, the amount of $1,035 would cause undue hardship on myself due to the amount of debt that I have and the amount of income that I have. Also, I would like to have my physical parenting time returned back to my 3 days a week that I had previously. It was dropped to 1 day after a financial dispute. I was scrambling together to give her $700 a month. And I was only able to give her $600 a month 1 month after I had to borrow from her credit card and borrow from these different components to get her the money. And she decided that I not only owed her that money, but I owed her a $50 late fee on top of that. After that, she decided to change the schedule to 1 day per week. I didn't want to fight with her. I wanted to have my day in court to discuss that. But the 52 nights over week has hurt me emotionally, my children emotionally. X has mentioned to me that he does miss spending as much time as we had together. So I offered more parenting time because that's what I can offer. I cannot offer more financially than I was. I have about $6,000 in monthly debt and income of about 3,500. So every month I have to get creative on how to cover the bills. That including is one of those bills. Um, Even when we had equal parenting time, when I had the children Tuesday, Thursday, Saturday, and half of Sunday, I was still paying her $700 on top of me having the kids equal time. I help provide a phone for her. I provide a phone for the children. I helped her when she initially moved out with a car with vehicle insurance. I helped her sign her lease on her home when she first moved in. So I've done everything I could to be a good model father, to take care of my children. Um, I have been villainized in this whole process, but I am doing everything I can to be a father. I didn't have a father growing up, so I wanted to make sure I'm in my children's life and present. So I do everything I can with my children over the summer. We take them to YMCA, so I pay a $46 a month YMCA membership. I take them to Chuck E. Cheese, which is a $12 a month membership. I pay their phone bill, which is $80 a month, and then the insurance it's $200 for just me, but adding the two additional children is additional $200 as well. So I'm not sure where the calculation is. And then on top of that, she's limited now that she's limited from Tuesday, Thursday to only Saturday. Only having the children on Saturdays, hindered me from making any additional income as well. Operating a business or anything, a side hustle, because Saturday is a primary day for that. So um, I've been hurt
Okay,
by this whole
I got
process. Yeah,
well, first of all, I don't know who's villainized you because I certainly haven't, and I'm
yeah, I
pretty
know.
sure Miss Rummelt hasn't as well. Let me first of all tell you, insofar as the parenting time is concerned, um, you have a couple of different options. Right now, you have nothing on paper, and verbal agreements, as I always say, are not worth the paper they're printed on. If you have a verbal agreement, people can duck and dive and not comply, those types of things. So there's a couple of options you have. One, you can ask the friend of the court to conduct what's called facilitative parenting time. That's where they'll sit down with you and sit down with the other side and try and hammer out a schedule and put it on paper what the parties have thus far been elusive in getting out as far as some written schedule. Your position as far as the child sport's a little bit more problematic. The child support guidelines are in Michigan are what's called both presumptive and mandatory, meaning that they have to be followed and that the guidelines are presumed to be correct. There's always issues when it comes to this. Bills are an extremely important calculation in everybody's mind, everybody, to and including mine. Problem is the guidelines are more prejudicial when it comes to bills. There's only certain bills you can get credit for and deduct. So what you can do is if this amount is, if you wish me to take a look at child support and take a look at parenting time, what you would have to do is file a motion for both of those with me. I'm here every other Friday, most of the time, and I would be happy to entertain whatever thoughts you have as far as child support. In fact, I may even send it back to the friend of the court for another recommendation to me. But the fact is, I'm looking at this, the actual incomes were used for both parties. And the income is strictly based, I mean, the guidelines are strictly based on the income, and certain things you can deduct. Most bills are not it. So what I would tell you to do is, after today, is you can file a motion with me for specific parenting time and a review of your child support. Those are held every other Friday at this time, and I would be happy to listen to whatever you have. You can submit to me whatever you have as well, give you more time to somewhat prepare for it. And we'll cover those in that fashion. That's what I can tell you. Okay.
Okay, and what are the name of the motion? Is it motion for child support and motion for parenting time?
Correct.
Okay, thank you.
And if you're choosing to represent yourself, the Legal Assistance Center on the 5th floor has all these forms that you can stop down and utilize. They're not attorneys there, but they do an excellent job of pointing people in the right direction. And I'm a big fan of the Legal Assistance Center. So if you're going to represent yourself, that's probably the first place that I would go. They're on the 5th floor of the courthouse. Okay.
Your Honor.
I really don't need that, Ms. Harmsen. I'm going to enter this subject to those things. I know you probably have a lot of response to what he has said, and it's not that it's not important. It's just that I'm telling him to, in essence, save it for a motion, and I'm going to tell you the same thing too. When he files a motion, he's got to let you know in time, 9 days if by mail, 7 days if 9 days by mail, 7 days if hand delivered. And we'll cover all of that at that time. I promise I'll listen to every word you say. Okay.
Understand. My questions are more in regard to child support right now. The court should probably know that has no overnight visits as of now. And I'm wondering about back pay. And
Yeah.
I'm also wondering who is responsible for the deductible on my children's insurance. Our son has surgery Monday. And
I'm going to
believe that-
stop you there, Ms. Harmsen. These are questions that I cannot answer for you.
Okay.
You would definitely need to seek out legal advice. The effect date per the request by the prosecutor's office is 10/1, I believe. So it's back that far, and that's in accordance with the law. But if you think I should take a look further back, you can put that in your answer to Mr. Whitmore's motion. Okay.
I was told that I could file up to like 3 months of back pay, just because Mr. Whitmore only paid in August $350.
Yeah, I can't answer that for you today, Ms. Harmsen. I'd be happy to answer it at a standalone motion.
Oh, okay.
I'll answer all those questions for you, I promise. Okay. Ms. Rummelt, anything from your end?
No, Your Honor, I will just make the correction on the effective date. And again, I apologize.
That's fine. Thank you. And you submit that via DocuSign. Folks, I know you and I are probably going to see each other again. I wish you the best, and you can both sign off. We're adjourned. Thank you. First on my screen, on behalf of the people of the state of Michigan, Assistant Kent County Prosecuting Attorney Margaret Rummelt. Ms. Rummelt, good morning again to you.
Good morning.
And the plaintiff in this matter, Janiyah Jackson, joins us. Ms. Jackson, good morning to you. And is Kavion Walden Michael, and I hope I didn't butcher that, but is Kavion present on the call? I don't see him. I will note for the record that this matter was noticed by Ms. Rummelt for today's date on this platform at 8:30. It is now 8:56 by my courtroom clock. And Ms. Rummel, if you will indulge me, hopefully we'll get this one right. A complaint for paternity was filed in this matter on August 13 of this year. A motion for alternate service pursuant to MCR 2.105J as in John was filed, and out of that, an order for alternate service was entered on September 11 of 2025, which provided for first-class mail and tacking or delivery. So it was served by tacking on September 16 of 2025. The support calculations are in this matter reserved as, according to my information, the defendant is currently enrolled full-time in high school. The uninsured medical percentage is also reserved, as is the overnights, as I was going to say as Section 40 birth expenses, but those are in fact waived. Ms. Rummel, anything you want to add to this before we hear from Ms. Jackson?
Only that this was noticed for a hearing. It should be a default, but because of the age of the parties and because this is a paternity matter, we did want to give Mr. Walden Michael one last chance to participate. He has not, but no genetic testing has been ordered or conducted in this matter. So the paternity will be established essentially by default. Thank you.
Or requested, I should add.
Or requested.
So, Ms. Jackson, anything you want to add?
No.
Okay. I'm going to enter this judgment today that will obviously declare that Mr. Walden Michael is indeed the father of the child whose initials are JMK. I will tell the parties to pay particular attention to paragraph 14 of the judgment of paternity and paragraph 13 of the Uniform Child Support Order as to important reporting requirements. Ms. Rummel, anything else?
No, thank you, Your Honor.
All right, you are all set. Thank you very much. You can sign off, Ms. Jackson, and I wish you the best of luck. Ms. Rummel, thank you very much for your time today, and we're adjourned on that matter.
Thank you.
Thank you.
On behalf of the plaintiff, Attorney Renee Wagonar. Ms. Wagonar, good morning to you.
Good morning.
And on behalf of the defendant, Brittany Avery, Attorney Sean Cox. Mr. Cox, good morning.
Good morning, Your Honor. Good to see you.
You too. And our plaintiff joins us next, Jonathan Zamora. Mr. Zamora, good morning.
Good morning, Your Honor.
And finally, last but certainly not least, the defendant in this matter, Brittany Avery. Ms. Avery, good morning to you.
Good morning.
So I have read your motion, Mr. Cox, and I have also read the response by Ms. Wagonar. Let me start with you, Mr. Cox. Is there anything you want to add to it, accentuate, highlight that you don't think I already know? And then we'll hear from Ms. Wagonar.
Thank you, Your Honor. Fortunately, I'll be brief because I know that, as always, you read everything very thoroughly, and I'll just make 2 points, Your Honor. One is that the previous order clearly says that there will be an automatic review of parenting time in 1 year, meaning either party can bring this before the court to review parenting time without a proper cause or change of circumstances. That's point number one. Point number two, and I'm going to shut up, Your Honor. Point number two is Ms. Wagonar and I have a very strong proclivity to settle cases together. This case seems to be screaming for mediation, Your Honor, and that's just my thought on that. And I'll give you back to the floor.
Thank you. Ms. Wagonar.
Your Honor, I also know you read my response, so I don't necessarily have anything to add. I normally am a strong proponent of mediation. I'm not sure that my client's position would be agreeable to changing any type of parenting time at this point, hence our request to ask to deny the motion. And so I would just simply follow the rest of my prayer for relief.
Thank you. Well, mediation is one of those odd things that I always take what the attorneys tell me as far as that goes, and I always ask them if mediation. I know I can send virtually anything pursuant to MCR 3.216 to mediation, but I also don't want it to be a complete waste of time. Here's what I know. The last parenting time order was dated not that long ago, August 29 of this year, which provided to the parties an automatic threshold determination based on either party's request. Not quite sure how I feel about those. I'm sort of, it seems like that is kind of an interesting perspective as far as what courts need to find as far as threshold, but I won't, as I did not sign that order because when this first came up and I saw it, I'm going, I would have never signed it, but I saw Judge Gottlieb did. And so I will reluctantly find that based upon the simple request of the parties, that I will send the matter to the friend of the court for an investigation recommendation relative to parenting time. The fees will be split. One of the things that caught my eye in not only the motion, but in the response is this whole issue of counseling. And I somewhat got the impression that the parties think that the children, I use their initials, JDZ, who I think is 10 now, right? And LAZ, who is 9. I think JDZ is going to be 10 only for a short time longer. But I think there was mention of counseling. I'm pretty standard with that as far as counseling. If the parties feel that children need counseling, I tell them to go pick a counselor. If they don't agree with it or can't agree on who should be the counselor, then the attorneys can submit a couple of names to me, and I'll draw them randomly, and that will be the one. The last thing I want to tell you before I send John your way with the order of reference is extracurricular activities are not legal custody decisions, and I don't spend a whole lot of time dealing with those in the context of parent squabbles. I'm pretty consistent with this too. When you've been doing this as long as I have, you kind of get a tell, and your attorneys will know that better than anybody, that my theory or my position on extracurricular activities is your time and your dime. And that's how I look at extracurricular activities in the future. So maybe if that helps guide the discussions going forward. I will obviously reserve the issue of mediation if Mr. Cox and Ms. Wagoner, who are two excellent attorneys, come to the conclusion that, yeah, maybe it'll help. I certainly have no problem doing that, but I will wait to hear from them. So in the meantime, I will send it to the friend of the court. Fees will be split, and I will sign that order today. Mr. Cox, anything else I can do for you?
Nothing further, Your Honor. Thank you. Have a good weekend.
You too. Ms. Wagoner, how about you?
Nothing further. Thank you.
Thank you both, Mr. Zamora, Ms. Avery. Best of luck to both of you going forward as you discuss some difficult issues coming up. We're adjourned on that one.
Thank you, Your Honor.
Good morning, everybody. First on my screen is the defendant, Mr. Rashid Aska. Mr. Aska, good morning to you.
Good morning, Your Honor.
And next on my screen is the plaintiff in this matter, Vicky Ann Rodriguez. Ms. Rodriguez, good morning to you.
Good morning.
And on behalf of the people, Assistant Kent County Prosecuting Attorney Caleb Gonzalez. Mr. Gonzalez, good morning to you.
Good morning, Your Honor.
So if you will permit me, Mr. Gonzalez, a complaint for paternity was filed on July 23rd of this year. It was served upon Mr. Aska on the 5th of August of this year. An order for genetic testing was entered on August 8th of 2025. Mr. Aska did file an answer on the 11th of August of 2025. The court was in receipt of, and genetic test results were filed on the 15th of September, which indicated to a scientific certainty that Mr. Aska is indeed the father of the child, who I will use initials ER. A pre-hearing was scheduled with the prosecutor's office on October 2nd of this year at 11:30 a.m. The support as calculated by Mr. Gonzalez called for base support in the amount of $792 per month, $10 in ordinary medical for a total of $802 per month commencing August 1 of 2025. There were 0 overnights used in the calculus, and the calculus was based on actual wages for both parties. The uninsured medical split was 41% for plaintiff, 59% for the defendant. The Section 4D birth expenses were waived. I did not see a request for genetic test costs in there, Mr. Gonzalez. I don't know if that was just an oversight, but that is what is contained in the order. Is there anything you'd like to add, Mr. Gonzalez, or would you like me to defer to the parties first?
No, Your Honor, I do. I would like to add that the genetic test fee of $66 be added. That was an oversight on our part.
Okay.
And Your Honor, I also want to add that they both had an agreed amount to an addendum to add, but then they had changed their minds. So they might have a lot to say about that. So that's it, Your Honor.
And they certainly will be given every opportunity to say it, but not today, probably, because it would require a subsequent motion. But Ms. Rodriguez, anything you want to state?
I mean, yeah, we did have an agreement prior before, and then I did end up changing my mind, but he has been very helpful when it comes to the child. Whenever he needs anything, he is willing. That's pretty much all I have to say.
Okay. Mr. Aska, what anything you want to add today?
No.
Okay. Well, I will note that, and I really appreciate that, Ms. Rodriguez. You don't always hear that every day, and I appreciate the candor with regards to agreements. Agreements are interesting things, and you have to be real careful when you come up with agreements regarding child support whenever there's any state assistance being received, Medicaid, food stamps, cash grants, rent assistance, anything. The state is grumpy when it comes to parties trying to do that. There's ways to do it, but if the parties at another point reach some sort of agreement you know where to find me. I'd be right here every other Friday, most of the time. And I'd be happy to listen at that time to anything either one of you has to tell me. But Mr. Gonzalez, I will sign via DocuSign with and I take it the the test costs are 66 at a rate of an extra 22 per month until taken care of. Is that fair to say?
That is correct, Your Honor. Yeah, we all arrears are, usually at a $50 rate, and then till paid.
Thank you very much. All right, I will sign upon presentation. Thank you all very much for being here today. And good luck in the future. And we are adjourned. Thank you.
Thank you, Your Honor. Have a great weekend.
You too. Round and round we go. Nice to see everybody again. I've invited staff attorney for the front of the court, Megan Lipford here. Ms. Lipford, good morning. Thank you for being here.
Good morning, Your Honor.
Ms. McLean, good morning. Thank you for being here.
Morning, Your Honor.
And Attorney Matthew Reens appears on behalf of Mr. Taylor. Mr. Reens, good morning to you.
Good morning, Your Honor.
So I have read, I was able to track down the brief, and I've read that. I appreciate that, Ms. McLean, very helpful. Thank you. I've read the objections. Obviously, the objections are timely. Mr. Reens, this has really been a case of trying to get all the information from your client. It's been extremely frustrating from everybody on down to and including Mr. Baker from the front of the court. Anything in that regard you can tell me before I hear from Ms. McLean?
I can, Your Honor. After having been retained by Mr. Taylor, I asked him to provide to me documentation verifying his sources of income. Those sources of income do track what Ms. McLean thought his sources of income were. And so I have a statement from his federal employee retirement system. I have a statement from the military retirement system. And I have a statement from the VA as well. Ms. McLean's ideas of his amounts of income that were stated in her objection were almost spot on, but for VA, which is about $200 higher each month. So I have all of that information. I also have information showing the amount and when he received his inheritance. I think that having received that information and seeing that that establishes an amount of income that is actually higher than what his employment income was, it would seem to me that we could resolve this case fairly quickly.
Ms. McLean.
Thank you, Your Honor. I'm assuming that maybe at this point in time, just maybe with Mr. Reen's involvement, send it back to the front of the court with this new information and have them issue a recommended order. I have no objection to that. I just, again, my client's been very frustrated with this kind of failure to cooperate. He only asked for something and failure to cooperate. It's been very frustrating.
Yeah, it's also been, and I can understand that. It'd be frustrating to me. It would be, it's equally going to be frustrating to Mr. Baker, but if Miss Lipford can maybe bring a dozen donuts to him and see if he would be willing to rerun it with all this new information. Also, I would what I would like to do is just to make sure the record is crystal clear that that the parties, and I think we should do this with a signed stipulation, that Michigan can continue to exercise jurisdiction, and that the provisions of the UIFSA found at MCL 552.2101 et sec will not apply in this case. So, Mr. Reens, if you can circulate that stipulation, then we have it all clear on the record. I'll wait to get something from Mr. Baker's office and see if perhaps that does it. If not, the parties are free to contact my clerk if they think mediation would be helpful. Usually when I got two really good attorneys on it, that can get it done, but sometimes it can't. And other than that, once we get that, we can just set up an evidence. I don't want to have to come back with, you can file objections, but I don't need a hearing on it. Okay, if there's objections to it, just exchange them, make sure I get it, and then we'll just set it up for an evidentiary hearing after I receive those. Pretty clear, Mr. Reens, on what I need that stipulation to say.
I think so, Your Honor, but let me clarify. We would be stipulating that Michigan does have continuing jurisdiction regarding the issue of enforcement and modification of child support that MCL 552.2101 et sec does not prevent the continuation of that exercise of jurisdiction. This matter is referred back to the friend of the court for a new recommendation. I will provide to the friend of the court, to Ms. Lippert, if that's okay, and she can get that to Mr. Baker, the information I have. I will also copy that to Ms. McLean. We will get that new recommendation. If either party objects, we would simply file that objection and ask for an evidentiary hearing rather than taking up the court's time on another Friday morning.
Yeah, I don't want to have to wake up Ms. Clark at 0500 hours all the time, or Mr. Taylor. Ms. McLean, anything further?
No, thank you. I'm assuming Mr. Reens is going to draft that and send it to me.
I will do so.
Okay, thank you so much. Thank you, Your Honor. Have a great day.
Perfect. You too. Thank you all very much, and thank you for your service as always.
Thank you, Your Honor.
Thank you.
Yeah, hello. Come on. Here on the road.
I'm usually good for about one of those every motion cycle that someone just kind of hollers in when they jump on. So let me see if I can't restore some dignity here. First on my screen is the plaintiff, Ms. Mancha Torres. Ms. Mancha Torres, good morning to you.
Good morning, Your Honor.
And next on my screen is on behalf of plaintiff attorney Leslie Curry. Ms. Curry, good morning to you.
Good morning.
And finally, last but certainly not least, the defendant in this motion, Robert Durham. Mr. Durham, good morning.
Good morning.
I have read your motion. Is there anything you want to add, highlight, accentuate? I'll turn things over to you, and then I will hear from Ms. Curry.
Yeah, I'm just really, it gets me a little bit about paying child support for, I don't mind paying child support, but I want to be able to see my kids like I see the other two. That's basically one of my concerns. And then I wanted my child support a little bit lower.
Yeah.
And I have 0 overnights, 0.
Understood. See, that's one of the things with child support that's a little different from how everybody understands things is that when you make monthly payments for a car, you expect to be able to drive it. It doesn't work quite that way in the child support parenting time area. They are two separate tracks. I have a lot of men and women who have parenting time with their kids that don't pay any child support for one reason or the other. And I have a lot of people on my docket who are paying full child support and have no parenting time rights
Yep.
with their child. So it's frustrating. I get it. Ms. Curry, anything you want to add here?
Thank you, Referee Winter. I did submit a response to the motion that I'm assuming that the court had an opportunity to review.
Yes,
I
I
tried
did.
to lay out as clearly as I could, both for the court and Mr. Durham, each of the pieces to this and what I thought were the appropriate remedies and legal conclusions. So we would ask the court to deny the request to modify physical custody if that's a part of Mr. Durham's motion, because this order was just entered, and there's no change of circumstances or proper cause since its entry. Regarding the request for joint legal custody and parenting time, we would ask that you refer that to the friend of the court for an evaluation and recommended order with the fees waived for both parties. And if you believe that you can make a determination as to interim parenting time in this little one's best interest before you get back the friend of the court recommendation, we would ask that you consider journeys for that under these circumstances.
Thank you. Well, one of the things that's interesting to me is that I know that ever since the case of Sims versus Verbrugge, 322 Michigan Appeal 205, 2017 case, there's been an uptick on requests for legal custody. The interesting thing about that Verbrugge case is that that only applies to DS support cases, because what the court in Verbrugge was trying to convey was that if paternity was established versus an affidavit of parentage or paternity, the language in that is not a judicial determination. The language, however, in a judgment of paternity is a lot different. And Verbrugge even points that out. When you have physical custody in a paternity matter, you also have the legal custody as well. But the defendant has filed a motion requesting a change of physical custody, and based upon case of Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case, this court needs proper cause or change of circumstances since custody was last visited approximately 70 days ago. The only thing that's listed are things that I give, obviously, a lot of credit to anybody for, such things as working at the same job for 7 years, having strollers, having all the facilities. I'm always troubled by when I read that he hasn't seen the child in 6 months. That is something that is concerning to me. Well, what I'm going to do is I am going to refer the issue of parenting time and legal custody to the friend of the court for an investigation and recommendation. I'm going to waive the fees for both parties. Obviously, legal aid's involved on this, and I will waive the fees for Mr. Durham as well. If there is going to, I have no objection to a referral to Journeys for parenting time. According to the response, apparently Mr. Durham, through maybe no fault of his, maybe fault of his, I don't know, but he has not seen this child who is, I think, one, but a couple of times in 16 months. And that's somewhat, it presents a difficult scenario. I think what I'm going to do, though, Ms. Curry, is I'm going to defer that to a motion by Mr. Durham. If he wishes to have interim parenting time, he can file that with me. I don't have enough facts about the nature of his contact. I think that needs to be ferreted out, why it's only been that way. So I will reserve interim parenting time for a motion by Mr. Durham should he decide to do that. So you'll both be hearing from the front of the court. Make sure they have your correct addresses, that type of thing, because things will start happening fairly quick. Things get complicated from here on out, Mr. Durham. So if you feel that you can adequately represent your own interests, you may do that. But a lot of people find that they cannot. And if you are thinking about retaining counsel, you should probably do that pretty quick. Ms. Curry, anything else I can do for you?
Only Referee Winther to remind Mr. Durham, if he files a new motion, that he should send me a copy. I filed a new appearance this time to clarify my representation. This motion was obviously more than 21 days after the last one was filed, but he did not get a copy to me. Instead, he sent it to my client. So I would just like the court to remind him that from this point going forward, he should send anything he files to me.
Yeah, that's Mr. Durham. That's what I was referring to about things getting more complicated. The court rules require that since Ms. Curry is representing Ms. Mancha Torres, that you can't even serve Ms. Mancha Torres with anything. You have to serve those documents to Ms. Curry directly. And if you fill out a subsequent motion to do that, you should do that, or must do that according to the court rules, to her directly. Anything further, Ms. Curry?
No, I'm assuming that the court will do the referral order to the friend of the court, and then would you like me to do the other order?
You can. I don't know what you mean as far as,
I guess
making
just
sure
you
you're
order, you were reserving the
Yeah, you can do that.
question of interim parenting time. I don't think there's much for me to put in that order, but if you would like an order, I can do so.
I think I should, and plus, that would also reiterate the contact information you have so that Mr. Durham knows exactly where to send that. Mr. Durham, anything else?
No.
All right, you both are all set with me. Ms. Curry, always a pleasure. Thank you. And we're adjourned. You'll hear from the front of the court shortly. Make sure they got all your right information, okay? They don't forward mail. So hopefully we can get this figured out. Thank you very much.
Right, next is number 20 on our list. And that is case number 2207202 DM, Vander Veen versus Vander Veen. We thought we had Randal here, but I'm not seeing him at the moment.
I'll make sure I get to the all right. You are Kelly Vander Veen?
Yes.
Good morning again. You and I have met before. I know that.
We have. Good morning.
in another setting, right?
Correct.
So, is Randal Vander Veen or anybody on his behalf present in the virtual courtroom? I don't see him. I see Mr. Is it pronounced Copen or Copen?
Copen.
Copen. Mr. Copen, good morning to you.
Good morning.
So I have, let me tell you what I know, and then we'll hear from the parties. Parties were divorced by consent judgment of divorce dated July 26th of 2023. The presumed father, I got to give everybody their titles. The presumed father, since the child was born or conceived during their marriage, is one Randal Vander Veen. The alleged father is with us today, Mr. Josh Copen. And the child in question, KAC, I'll use her initials, is less than 2. So apparently, all the parties somewhat, at least it's represented in the motion by Mr. Copen, that all the parties are aware of this, all would be willing to come into a virtual court and acknowledge this type of biological relationship. Is that what I'm reading, Mr. Copen?
Yes.
Okay. And Ms. Vander Veen, is that your understanding?
No, Your Honor, I would actually like to have a genetic test ordered for confirmation.
Okay. That can be done. The court will order genetic testing pursuant to MCL 722.1443 parent 5. You would have to prepare an order for that, Ms. Vander Veen. That would be at they'll help you with that at the Legal Assistance Center. They will prepare or help you prepare that order, and it has to be sent to me. I will sign that, and we will see once the genetic test results come in where we go from there. Okay.
Sounds good.
Mr. Copen, any questions for me?
No.
All right. Then the sooner you get to the Legal Assistance Center for that order, Ms. Vander Veen, the sooner we'll get this matter moving for you. Okay.
I can
Thank
go
you.
down there and do the same thing, right?
You can.
Okay, perfect.
Okay. If you want to do that, that's fine, Mr. Copen.
Oh, absolutely.
Okay. Then
Thank you.
you can do that, and make sure I get a copy of it, and we'll, or because I have to sign the original, and then we'll get this matter moving.
Perfect.
Thank you.
Thank you.
All right. First on my screen is, wait a minute. I'm trying to see if this is, there you are. Your name is different on the sheet. So you prefer Perry?
Yes, that's my married name.
Okay. Miss Gloria Perry appears plaintiff in this matter. Miss Perry, good morning.
Good morning.
And Wesley Carter joins us, the defendant in this matter. Mr. Carter, good morning.
Good morning, Your Honor.
I have read your motion. Is there anything you'd like to add, accentuate, highlight, and then we'll hear from Ms. Perry?
No, I mean, the motion was just, it was pretty cut and dry, basically. But I would like to just say, I would like to extend a heartfelt thank you to Gloria for being here and allowing this to take place and taking time out of her day. And thank you for being here, Your Honor. So, like I said, the motion is pretty cut and dry. So other than that, I don't really have anything else to add.
Okay, I certainly might, but go ahead. Ms. Perry, anything you want to add?
No, Your Honor, I am actually a little surprised with this. I didn't realize that this was something that could be asked of. As far as the motion itself, I think I receive $62 a month. And I'm just shocked that this is being presented. So no, I'm just eager to hear what you have to say about this.
Well, I'm eager to hear what you have to say about this. I mean, he is requesting that I forgive a boatload of arrears, some of which are owed to you, and I'm curious as to what your.
Oh, I didn't agree to anything. I don't know if that's what's been stated, but I didn't agree to anything.
No, I know that. That's why you're here. I'm trying to ask what your position is on these for the record, because I don't have any position from you at this point.
My position is, honestly, I went through hardships with my children. Mr. Carter was not involved with them growing up, so I struggled a lot in my younger years. I'm doing very well now. I think if anything, I'm willing to, settle with a smaller amount if Mr. Carter is willing to agree to that. But ultimately, I'm not willing to dismiss it completely.
Well, let me explain how this works. You make some interesting points in your motion, but let me first of all give you kind of a lay of the land. First of all, you owe arrears to Miss Perry in the amount of $36,359.80. That's what you owe Miss Perry. You also owe $13,578.39 to the state of Michigan. You also owe $1,275.50 to the Kent County. So what I can do and what I can't do, I can't waive arrears owed to either the state of Michigan. That has to be waived by the Attorney General. I can't waive any fees or any of that owed to Mom because that's her money, not mine. I can't do that. Now, I could conceivably forgive or waive the $1,275.50 to Kent County, but I would need more information on that from you. But I think what you are going to have to do, Mr. Carter, is I think you're going to have to try and reach some sort of an agreement with Miss Perry, because that's got the bulk of it. Then the $13,000 left to the state of Michigan, you could probably find a sympathetic soul in Lansing who would give you a break on that as well. And then once those things are done, if all you have left is the $1,200 owed to the county, I would probably toss that in. The problem you also have is because I checked on this and the passport issue is not only being held by Kent County, but it's being held by the state of California. Okay. And the state of California, at least I'm told anyway, and I don't know because I don't practice there, never did, that they are very reluctant to give passports back until the parties have straightened out the arrears. So if if you can get the situation to with Miss Perry resolved, the situation with the state resolved, and the issue of passport with California, come back here and I can probably do business with you on the $1,200 you owe Kent County. And then I may even be in a position to give you back your passport. But right now, even an order giving it back to you wouldn't do any good because California is holding on to it. Does that make sense to you?
Of course.
Okay. So that's kind of the route I'll follow. I'll deny your motion without prejudice, meaning you can bring it back here, but you've got some people and issues to deal with first, and then you can come back here. Okay?
Sounds good.
Nice to see you both.
Thank you.
Thank you, Your Honor.
You bet. You're all set. All right. Let me see. First on my screen is the defendant in this matter, it says John Andrew Johnson. Do you prefer Andy?
Yes, Your Honor.
All right. But I'll call you Mr. Johnson. I just want to make sure it's right. Mr. Johnson, good morning.
Good morning, Your Honor.
Next on my screen, on behalf of the plaintiff, Tiffany Johnson, her attorney Sean Cox. Mr. Cox, nice to see you and good morning.
Good morning, Your Honor. Nice to see you as well.
Last but certainly not least, the plaintiff in this matter, Tiffany Johnson. Ms. Johnson, good morning to you.
Morning, Your Honor.
So I have read your motion, Mr. Cox. Thank you. Is there anything you want to add, highlight, accentuate? I will turn to you, and then I'll tell you what I know, and then we'll hear from Mr. Johnson.
All right. Thank you, Your Honor. Your Honor, my job was incredibly easy in this case because I simply was a pencil pusher, to be quite honest, Your Honor. These folks came together with a consent judgment of divorce, not guided by me in any way, shape, or form. We didn't even go to mediation, Your Honor. It was just these two adults coming together on every issue: custody, parenting time, child support, including real estate, one of the nagging issues at hand here, Your Honor. My client had hoped wholeheartedly that agreeing to this divorce, coming together, would calm down the difficulties between the parties. And frankly, Your Honor, I'm trying to be as diplomatic as I can, but the defendant is essentially stalking and harassing my client, Your Honor. And it's problematic because, not only is that a problem to begin with, but when we're involving the minor child, it's just horrible. And it's difficult because you say to yourself, okay, how can I help my client? Should she file a personal protection order? What kind of relief can she seek? And it's just been miserable. So I realize, Your Honor, there's just not an objective way to tackle something like, this level of disparagement and harassment. I mean, it's just social media, Facebook, TikTok. It's just an all-out stalking campaign of harassment. And I wish there was a way we could remedy this or put some sort of restraining order that says this conduct can't occur moving forward, Your Honor. And I realize on the real estate, Your Honor, that hey, they relied heavily on the belief that they can move forward on this together, and they just can't because unfortunately, the defendant thinks that he can still come on to my wife or his ex-wife's property whenever he wants. That's just so intrusive to her, and she can't even be comfortable in her own home. And in this property provision where they're stuck with each other until the child graduates is just horrible. So we've laid out, Your Honor, I think a reasonable approach to resolve that issue and put both the parties out of their misery, Your Honor. And in addition to that, Your Honor, I think the rest of what we're asking for is just cleaning up the stuff that needs to be cleaned up that he hasn't done on the judgment, dealing with these titles, just getting these things done that were supposed to be done in the judgment, Your Honor. And I appreciate the opportunity to speak, and I would rely on our motion and ask that you consider all of our relief today, Your Honor. Thank you.
Thank you. The one question I did have is your motion is in essence asking this court to amend a property provision of a judgment, and aren't I prohibited by such cases as Colestock versus Colestock, 135 Michigan Appeal 393, from sticking my nose into what the parties actually resolved, unless they are ambiguous, or there's allegations of fraud, mistake, et cetera, et cetera. Any thoughts on that?
Yes, Your Honor. I mean, that is the law. There's no question. And as I explained to my client, I mean, we are asking for equitable relief here, and I'm making an equitable argument that perhaps the court might consider, having them do this. And the difficulty too, Your Honor, is that Mr. Johnson is not represented by counsel. That there's nothing wrong with that. That's not a negative, but it probably would have been a scenario where I could have contacted an attorney and see if he might be interested in this kind of resolution. But as I've explained to my client, if Mr. Johnson tells the court this morning he's not interested in that resolution, that she will be stuck with this language, Your Honor. That is true.
All right, Mr. Johnson, what say you?
Yes, Your Honor. Well, the accusation of stalking is a gross misrepresentation and over-exaggeration of the truth. The document that was presented to you includes false allegations as well as 2 misquotes. I have no objection to settling the property. I have not been stalking her. I have not been to the house, with the exception of invited to exchange custody of John. And there was one time where I was invited. I happened to be in town. I live an hour away. I happened to be in town for a dental appointment. And my son contacted me and asked me to come over for 10 minutes to help him with the project in the garage. Again, I have no objection to settling the property. The purpose for us doing that was, it was in both of our financial interest. And it was for the best of John to be able to continue to experience both his house and where I'm living now, that what used to be our cottage, to create less stress for him. It was always about him, and it also financially benefited her much more than me. I'm without the equity from the difference in the properties right now. But I absolutely, if she can afford it, would not object to settling the properties.
Okay. Give you the last word, Mr. Cox.
Your Honor, I appreciate the response, and if we could perhaps work out something on the real estate, I'm happy to discuss that with Mr. Johnson at a later time. So I appreciate that. Thank you, Your Honor.
Well, obviously, going down your request for relief on page 5 of your motion, we can start with paragraph A. Mr. Johnson doesn't have a problem with that, so let's do it immediately and get the property taken care of. Same with B. Same with C.
Your Honor, may I make a request?
Sure.
May I request? I like to keep things simple. For the property settlement, if we're going to go into ordering that right now, I would like to, in order to make it simple, I would be willing to relinquish the house to Tiffany if she will relinquish the cottage, the truck, and $100,000 to me.
Well, obviously, as much as I'd like to engage in negotiations on the record, I can't do that. But I would invite you to contact Mr. Cox, who is very good at that, and he can handle that situation. And what's a little disappointing before I get into the rest of it. So A, B, and C are sound like okay, Mr. Cox. So go ahead and put that in your order.
Thank you, Your Honor.
Now, as far as D is concerned, and I'm going to talk to the parties about this because I always have well-intentioned parents that do things to their financial detriment in the hopes that it somewhat blunts the effect that divorces have on kids, especially, and I'm going to use his initials, JMJ, who's 12. And I think that that's laudable. The problem is when if some of these things are true, and I don't know if they are or not because I don't even know either one of you. But what all the good you're doing to try and blunt this can be undone in about 30 seconds via social media, that type of thing. So what I think I'm going to do is, in addition to the things already covered, is I am going to order that the parties enroll for their own protection, in my view, in our family wizard with the tone meter in the next 30 days. That can be done online. It's very simple to do. And that should be how, we'll try it for a year because that's how long the membership goes for. And if it is, if it solves the problem, if parties go, okay, I think we're in a different place, then they can let it expire. Otherwise, I'll review or I'll entertain a request to renew it after the end of a year. I want that done in the next 30 days. Then I want an order. I really don't want to add a personal protection order to this equation. I'm not adverse to it, but I want to try and see if I can resolve it this way first. So let's put in the order that neither party is to enter the premises of the other without the express written permission of the other party. That way everybody's protected. There's no nothing left to chance. And your judgment is fairly new, April of 2025. So I'm going to chalk up all this stuff to two people who are trying to figure out how to act and react with one another as a divorced couple and as co-parents. So, but I'm hoping these measures tap that down and that we don't have any more of these incidents. And then we'll see where we go from here. Obviously, you know, we have a robust PPO department. It's available, but I'd rather try this first, Mr. Cox. Is there any question of what I need the order to say?
No, Your Honor. Thank you very much.
Okay. All right. So now you guys have been to court once, post-judgment. Things can either turn around for the better or things can get dramatically worse. And I'm hoping for the latter. I want things to get better between you two because, you know, you both are adults. I know you can handle each other and deal with each other, but your son didn't sign on for this. And I don't want him in the middle of this. And if you don't think he picks up on the stress that's going on between you two, then you don't give him enough credit, because I can tell you when he's 18, he'll let both of you know what he thinks of all of this. But until then, let's keep him out of the picture, please. Thank you both. I wish you the best of luck going forward, and we're adjourned. Thank you.
Thank you, Your Honor. Have a nice weekend.
Cool. All right. Is it Jonte?
Yeah,
Jones?
Yes, sir. Jonte Jones.
Mr. Jones, good morning to you.
Good morning.
And you are Sharmika Naves?
Yes.
All right, Ms. Naves, good morning to you.
Good morning.
So I have read your motion, Mr. Jones. You got a copy of that, did you not, Ms. Naves?
Yes, I did.
Okay. Let me tell you what I know, and then I'll hear from both of you. What I know is that the last custody, parenting time, and child support order was dated not that long ago, August 28th of 2025. And the parties were granted joint legal and physical custody of their child, who I'll use the initials KAJ, relative to the dependency exemptions. What do you want to tell me on that? Mr. Jones, it's your motion.
Oh, I just the judge, she granted me joint custody. I just feel like everything should be fair. I have KJ from Friday to Friday. We do a week on, week off. When she's with me, I provide clothes, food, transportation to school. I'll take her to doctor appointments. Like everything's pretty fair, except for that I'm the filing of the taxes. She just turned 8. I've never ever filed for her, and I've been in her life since birth. I submitted my insurance, that I pay for her every week. So it's like I don't think what I'm asking for is unfair. FOC granted me odd years as far as like Thanksgiving and Christmas and stuff like that. So I was asking that if it is granted, that I'll be granted odd years for the tax deductions. That way everything is together and nothing is confused as far as like who turn it is to file and stuff like that.
Ms. Naves, your thoughts, please.
I don't have no problem with it, but we did have a talk previous before all this happened. I did give a call out. I did reach out to him and let him know that I was going through financial situations, and I was asking him, is there some way we can drop the child support? So we did agreed on that, and we were supposed to come up there and file for that, but turned around and I'm here. So I did receive the paper, I did read it, and I don't have a problem with it. I did let him know before this even happened that I didn't have a problem of going back and forth with filing our child for taxes. So that never been an issue with me, and it's still not an issue with me.
Okay, so so he can claim KAJ in odd years, and you can claim KAJ in even years.
That's correct.
Okay. Then, Mr. Jones, you need to prepare an order. And let me tell you how you do that. What you do is you go to the 5th floor Legal Assistance Center. Tell them that you need to prepare an order, that they will give you a piece of paper that will say order on it and have a bunch of blank lines. And then you put what the agreement is, that you will claim KAJ in odd tax years for all state, federal, local purposes, and Ms. Naves will claim KAJ in all even years. Now, just remember something, that when you file your taxes, you're filing it in an even year, but it's for an odd year's income. You understand that, right?
Yeah. Yes, sir.
Okay.
Yeah.
You understand? I just want to, because some people get a little confused about that.
But basically, I would file this year because it would be, I know what you mean.
All right. So prep that order, get it to me, and get a copy to Ms. Naves, and I will sign it. How's that?
So do I gotta wait for your judgment to come or do it now?
Well, you have to, you're the one preparing the order. So you have to prepare that order now and get it to me, and get it to Ms. Naves. And then once I sign that, you will be good to go.
All right.
Okay.
Yeah.
And a lot of times there's forms the IRS might have you have to fill out. And your order should also say that parties shall cooperate and sign whatever orders that are necessary to carry this out. Okay. It's a good way to do things, just in case the IRS needs another form by the other party every other year or whatever. Okay.
All right.
You're all
I
set.
have a question, Your Honor. Do we both got to go down there and get the paper, or he can just go down there and fill out himself, or do we both got to sign the paper?
Well, you both have to sign it, but he can go down there himself and fill it out.
Oh.
He can just send it to you or drop it off at your house. And then once you
Okay.
both sign it, it's got to get to me. And then I have to sign it. And then we're good to roll. Okay.
Okay.
All right. Thank you both very much. Wish you both the best going forward, and you can sign off. Thank you.
Thank you.
All right. Thank you.
Next is number 12 on our list. Case number 2505440 DS Newkirk versus Johnson.
All right. First on my screen is the moving party and defendant, Vance Johnson. Mr. Johnson, good morning.
Good morning, Your Honor.
Next on my screen is Marissa Newkirk. Miss Newkirk, good morning to you.
Good morning.
I have read your motion, Mr. Vance, Mr. Johnson, I'm sorry. I take it you got a copy of that too, Miss Newkirk?
Yes.
Okay. Anything you want to add to that before I hear from Miss Newkirk?
Honestly, it's just to lower my child support. You know, I'm trying to put them on my benefits. I don't have a social security number. I asked her, she won't give it to me. And also, you know, I pay bills. I have my kids on the days I have off. And the days I work, I don't work 5 days a week. I work at Blown Film 12 hours. So I work today from Friday to Sunday, have Monday, Tuesday off, and I work Wednesday, Thursday. And, you know, it just keep repeating. So, you know, I have my kids, I drop my kids off at school, pick them up. And my other two kids recently just moved back here. And I'm just trying to stay afloat because I feel like my child support is just too high right now.
Okay. Couple of questions. Well, one question for Ms. Newkirk. In your response, which I read, it says that, which kind of confused me. It said you were not properly served with the subpoena. What subpoena?
I was under the impression that he had to send it via certified mail. That was all that I believed, that it was improperly served.
Okay, that's not, first of all, it's not correct. Motions can be served by first-class mail, not certified mail. And it's not a subpoena, it's a motion. Because you confused me by that language, because a subpoena is it's a whole different thing than just a motion. And there are different service requirements for a subpoena, but you were only served with a motion. So
that was my mistake.
Okay. I just wanted to make sure I'm not missing something here. So anything you want to tell me before I can tell you what I can do?
I know in my response, I asked for the lowering of the child support to be completely denied, which I still don't feel that it should be lowered. However, I suppose that I'm okay with it being lowered slightly. However, if it doesn't get lowered, between he and I, he's always telling me that he's not going to get the kids if he has to pay that full amount of child support, even though we do have parenting time through the friend of court. So it's almost like if it doesn't get lowered, I'm going to have to deal with him being mad at me as if this is my fault.
Well, that's, relationships are complicated things. And I don't want people to agree to things just to, I mean, agreeing to things to keep a good relationship between you and he that's valid. But I don't want you to feel intimidated or threatened in order to do this. So the question becomes is this. All right, if right now his child support obligation is $839 for 2 children and $555 for 1. So what are you contemplating it should be, or what would you agree that he pay?
I mean, to be quite honest, Your Honor, he hasn't, he hasn't paid any, I haven't gotten any child support from him this entire year. So I agree with the amount that they made, and I don't know what would be fair without shortchanging myself.
Well, I can't answer that for you because that's all. The only thing I can answer is what I can do. Okay. Because you two is, and if anybody's receiving any state assistance, Medicaid, food stamps, rent assistance, WIC, whatever, you have to be very careful about moving off the guidelines because the state of Michigan will not allow the parties to venture too far off what the guidelines call for. Here's what I know. As I said, the Uniform Child Support Order, the ink is barely dry on it. That's September 26th of 2025. It's $839 for 2 children and $555 for 1 child, based upon the friend of the court's figures of actual income for Mr. Johnson of $2,802.88 a month, and your actual income of $1,292.27 per month. Defendant was also given credit for 120 overnights. Plaintiff was given credit for 3 additional children, and defendant was given credit for 2 additional children. The guidelines from a legal perspective, and that's the only thing I can go by, appear appropriate. Well, what I can do is if you and Ms. Newkirk want to think about this a little bit, I can adjourn your motion without date, and you and her can sit down, or however you communicate, and come up with a number that you both can live with. And if you do that, then just go to the Legal Assistance Center and they'll help you prepare an order which does that. If at the end of the day, you two can't seem to get on the same page, then I'll listen to anything else you have to tell me. But right now, I think I would rather wait for the parties to have at least the opportunity to discuss it, not under the guise of emotion where everybody's on the spot, so to speak. They'll give you a chance to think about it, Ms. Newkirk, and hopefully you and Mr. Johnson can reach out to one another and come up with a number. But I'll clue you in. Unless these numbers that I just read to you are way off, unless there's been a real significant change of circumstance, then those are the numbers I'm stuck with, just like you are. But I'll give the parties the chance to try and resolve it themselves. And if not, you know where to find me. Okay.
Can I say something?
I don't think you need to at this point. Probably save it for Miss Newkirk. Unless you think it will help.
Yeah, I tried to negotiate with her. It was like a week ago. I said 400, 450. She said, no, too low, but she never gave me a price. So you said, you know.
Yeah, you guys can start. She has time to think about it and see what she wants to do. You don't have a lot of leverage here, Mr. Johnson. That's the problem. You don't
But
have
eight,
leverage.
30, yeah, I can't survive off that though. I'm trying.
I
It's hard.
understand. I see.
Yeah.
I get it. I get it. I get all of that. The problem is I can only go by numbers. I
Yeah,
have
and I
to.
got my other two
They,
kids back up there with me. I got
they've
4 kids in
already,
my house.
yeah, they've already given you credit for that. If any of these numbers are wrong, I'll fix them. But they've already, it looks like when I went through the uniform child support order, they've already given you credit for additional children, given her credit for additional children, and the guidelines look right to me. If the guidelines are wrong, then by all means, tell me where and we'll see if we can't fix them. But right now, everything looks fine to me. The only issue is whether you and her can come up with an agreement. You said 450, she says too low. So you wait for her answer back. And if you guys can't resolve it that way, you know where to find me. Okay?
Mhm. Yeah, we're not gonna be able to resolve it, but okay, Your Honor.
You're all set. Thank you very much.
Case number 2401154 DM, Perkins versus Perkins.
Well, before we get started, I am going to reserve court costs against both of you for $500 because I have warned you many motions ago, March, April, June, August. I'm not going to keep going through this. So I don't want your money right now, but I want you to think very highly of it because if I get any more of this stuff, then one of you is going to pay the 500 because I'm not going to keep doing this. This is ridiculous. And I would have thought that the parties would have picked up. I'm not a particularly complicated person to read. Both of you should either you both have terrible social skills or you both should have picked up on that a long time ago. That I'm not going to continue motion after motion after motion. Some people don't file one motion in 18 years. You people have filed, this is 1, 2, 3, 4, 5. 5 of them since March. And that's unacceptable, and it's an abuse of the process. And the next go around, if I get this thing back, $500 a piece, okay? Because now it's going to start costing people money. Now, here's what I see, and maybe correct me if I'm wrong. Once again, we're here because there are 2 stipulations, and neither one of you thinks the other should sign it. Is that what I'm seeing?
No, sir. We had an agreement, and when he went to court, he changed it. He refused to speak to me about it, and I attempted several times. And when he did, he had changed our agreement. I can't be asked to I can't be asked to agree to something that he changed last minute. That's unacceptable.
No, what's unacceptable is me having to pop in and figure out these things all the time. That's unacceptable.
I agree.
So
I agree.
And you're not listening to what I said. There are 2 proposed stipulations. One looks like it was written by you, and the other one looks like it was written by him. And the question becomes is, which one of these am I going to sign? That's really what it all comes down to. Right?
Yes, sir. And but
I mean,
once you you've read my response, and I hope that you see that I made every attempt to work this out with him. He refused to speak to me about the issue and then changed what we had agreed on last minute.
What did he change?
The birthdays.
Okay, what about the birthdays?
The that we had agreed that we would both be allowed to spend time with the children and have option to spend time with the children on their birthdays. That is most important to them because I've never missed a birthday.
His
not
doesn't even cover
voluntarily or
birth-
otherwise.
Well, it says every other birthday.
Right.
Okay. Is that the only
But
issue?
there should be, that was the only issue. And
And
we
I gotta-
agreed when we left court last time that we would both have option to spend time with them for their birthday.
Mr. Perkins.
And then, like I said,
Yes.
he waited until the very last day and changed that.
Mr. Perkins, what's going on?
Yes, sir. That when last time we were in court in front of you, I was at the courthouse. I picked up the stipulation paper for her. I wrote exactly what she wanted on it, and she refused to agree to it.
Sir, I
wrote
sent you
exactly what
screenshots of that. That is not true.
I wrote exactly what she said. I wrote exactly what she said.
See, here's what we're going to do. I'm going to put you on mute, and I'm going to put you on mute, because if you think I'm going to listen to the Hatfields and McCoys, you can shake your heads all you want. I don't care. Because I've already figured this situation out. So if the parties want to spend some money, they can, but there's absolutely no reason why the parties cannot spend equal amount of time on the children's birthdays. And the fact that I have to tell both of you that is outrageous in my view. So I'm going to sign the stipulation that looks like, anyway, it's been prepared by the defendant, that allows for 2 to 3 hours on the birthdays. I'm also going to add in that the court is sanctioning both parties $500 suspended. That means I don't want your money right now. I want this problem solved. Okay. And that's going to be the end of it. So I'm signing this one today, with the addition of court costs reserved against both parties. And maybe, just maybe, that will straighten things out. But I am not kidding anymore. This has to be, these are parental decisions, and they have to be straightened out by you two. So I'll sign it, and you'll be getting it in the mail. And I hope things from this point forward work out better for both of you. You can both, didn't I just see both of you as well?
It wasn't too long ago.
It was last year, Your Honor.
So, let me let's see if I can find these things. So I've got both of the motions. You received those as well, Miss. Is it Remar?
Reamer, yeah.
Reamer, okay.
Yeah.
So I've got both of those as well. Did you get a copy of both of those?
By both, do you mean the original? I got his like 1 paragraph motion that I submitted a response to, but I did not get anything further than that.
Wow, that's, you got what I got. I'm just saying if he's filed 2 motions.
I did
One of
not get the
them-
second motion.
One of them involves a motion to contest a tax refund offset and request for review. And the second one is a motion relative to child support. Did you get that one?
I just got the one that's like a handwritten paragraph. I don't, that kind of talks about both of those things within there. Is that what?
I got 2 different ones. One says, is entitled motion title, motion to contest tax refund offset and request for review. And the next
Okay.
one at the
That's
top
fine.
says motion regarding support.
I have the first one that you mentioned. I don't know. He was sending things to my lawyer who's no longer, I'm not using them, so I don't know.
That was my second question. Is Ms. Slate representing you in this matter?
No, they were she said they were after 21 days after the last hearing, they were no longer my attorney on file. So
Okay. Well, did you send all that stuff, Mr. Reamer, to Miss Slate instead of Miss Reamer?
I sent it to her attorneys because that's what the folks at Legal Assistance had on file and told me to send it to her attorneys.
Yeah, you can't, once a case
did-
is, hang on a
Sorry.
second. I got this, Miss Reamer, if that's okay with you.
Yeah, sorry.
You can't do it that way, Mr. Reamer. You have to, what I always tell people is, because it's a logical conclusion, but attorneys don't represent clients forever. Generally speaking, usually it's 3 weeks after the case in which they were retained is over, then they are no longer the attorneys. And generally speaking, when I see these situations, is probably the best advice that I can always give to people representing themselves is to contact the attorney's office directly and ask them if they're still representing her, and they probably could have gotten you that answer pretty quick and taken care of it that way, because I can't proceed when the motion is not served properly. So you're going to have to adjourn these and serve her directly 9 days by first class mail, 7 days by process server.
They were both sent at the same time, and I just did what Legal Assistance, told me to do. I can't afford a lawyer. I'm so.
Well, let me ask you this. Let me tell you this. I always have a rule of thumb, Mr. Reamer. You cannot rely on advice you don't pay for. And I know you didn't pay anybody at the Legal Assistance Center to give you advice, because they're not lawyers there, and they probably have about 50 signs that tell you that. So I don't fault you for doing it this way. I'm just telling you that I can't proceed today because of that, and that you need to renotice this for another motion day and send it to her directly at her last known address. And it has to be served at least 9 days if by mail, and you don't have to get crazy with it. It doesn't have to be certified or anything like that. First class mail is fine. Or if you're going to have a process server serve her, it has to be served 7 days before.
So just to make sure I understand, so I need to file a new motion, each one of those? No.
You need to file a renotice of motion. And what that does is that saves you from having to pay another filing fee. So whatever, if they charged you any filing fee for filing these motions,
They did.
You don't have to pay that again. That's why. So you would just renotice the motion. It's the same motions. I got them. And send them first class mail or process server to Susan directly. Okay. And the Legal Assistance Center has the renotice forms. So what I would do is I would renotice it so you don't have to pay another fee, send her copies of what you have filed already, and then she's got everything, I have everything, you have everything, and then we can get busy. That's what I would do.
Okay. I don't quite understand, just because in her responses, they're filed by attorney for defendant Allison Slate. It's listed right here.
Yeah, I can't make sense of any of that for you. All I can tell you is what the law lets me do. See, the problem is if I act on your motions today, anything I do would be automatically reversible because notice hasn't been provided. And I don't want to, because if that happens, then you would have to pay another fee to come back. And I don't want that. So that's the
Okay.
only reason I'm doing that.
Just to clarify though, because I'm super.
I can't keep clarifying it for
Okay,
you.
I'm just super confused why the
I
response.
can't help you with that, Mr. Reamer. That's why it's the law is it takes 7 years to go and graduate from law school. 3 years of law school, 4 years of college. It's confusing stuff. But there are people that can help you. However, there's a lot of attorneys now that handle what are called limited scope representation. They can prepare things for you and help you with service and all that, at not nearly the cost it is to represent you. So there's a lot of suggestions I have. The only thing I'm trying to tell you, and I know it's frustrating.
Very frustrating.
But I'm trying the courts are built for fairness, not for speed.
That's all I'm trying to do is get something that's fair.
Yeah, and that's what it's built for. And in order for it to be fair, everybody's got to know what everybody else's thought process is. So please do that. And I will see you back here when service is proper. Okay? You can sign off, both of you. Thank you very much.
Thank you, Your Honor.
We'll go to number 15, case number 0800671 DP Riley versus Singleton. And no appearance by the plaintiff.
All right. You are is it Daryl Singleton?
Yes.
All right. Good morning to you.
Good morning.
And is Amanda Riley or anybody on Miss Riley's behalf present in the virtual courtroom? I don't see her in there. So let me, if I could, Mr. Singleton, ask you a couple of questions.
Go ahead.
So it says on your motion that, and you signed it and dated it for October 23rd of 2025.
No,
Says
no.
Hang on, let me get the question out first, okay?
Yeah.
Because you're muting out my microphone
Gotcha.
when both of us talk at the same time, okay? So it says on a certificate of mailing, it says, I certify that on this date, and you signed it October 23 of 2025, that I served a copy of this motion and notice of motion or notice of hearing on the parties or their attorneys by first-class mail addressed to the last known address as defined by court rule. So my question is, did you in fact do that?
Yes.
Okay. And it didn't come back to you in the mail or anything like that?
No, it did not.
Okay. So she should have been aware of this, apparently is not here. Is that your understanding?
Correct.
Okay. So I read your motion. Let me see if I can help you out a little bit. So your son, he's 18 now. Is it Kaveri?
My daughter.
Or daughter, is it Kaveri? Kevri. Okay. So your daughter Kevri is 18 right now. Is that correct?
Yes, and graduated from high school.
Okay, well, that was my next question. And she graduated from high school as well, correct?
Correct.
Okay. And I did confirm with the staff attorney from the front of the court that the case is still charging. The emancipation date in the most recent uniform child support order was dated 5/31/26. So what they need from you and me is they need a new order to stop that. So here's my question to you. What month did she graduate?
She graduated June 2025.
Okay. So what the court rule or the child support guidelines say that effective July 1, your child support for this child will end. Okay. So they need an order at the front of the court before they can do anything. And you need to prepare that. And what you would do is you go to the 5th floor Legal Assistance Center. They will show you how to prepare an order terminating your child support. If for this child, I don't know if you have support obligations for any other children, but it's got to say specifically for this child and put her date of birth on there. Effective July 1, 2025. So you do that, and then they will show you how to get that to me, and then I will sign it, and then that should solve your problem.
So I went to the legal aid office and filled this out with them. And
yeah, I got it right in front of me.
Yes. So this is what they should have had written in the first place. So I have to spend another
No. This is not what they should have done in the first place. What they're doing is they're filing, they assisted you at no cost. It should have been.
No, it was sick. I had to pay for it.
You had to pay a motion fee probably, right?
Okay.
Okay. So what they did is help you prepare a motion. Now they got to help you prepare an order because you won your motion. Most people that win their motions are a little bit more happier than you are.
Okay. No,
Okay.
I didn't understand. I didn't understand it, Your Honor.
Okay. So, but you have to be very particular in this order. It's got to have your daughter's name and her date of birth. And it's also got to stop the child support effective July 1 of 2025. Because then they'll take care of any arrears you may owe from July, August, September, October. Okay.
Okay.
Head down to the 5th floor. The sooner I get that, and then you got to send her a copy, Miss Riley, even though she's not here. But I'll sign that, and that should take care of business for you.
Okay. All right.
Well,
Well, so you said 5th floor with the court just at the legal aid office, and
well, it's not. See, don't confuse it. It's not the legal aid office. It's the legal assistance center. Legal aid is a whole different ball game.
Okay.
They're not on the 5th floor, but legal assistance center. They'll help you out.
Gotcha. Okay.
Have a great weekend.
Thank you.
You bet.
Next is number 16. And that is case number 24110-960S, Rivera versus Freeney.
All right. First on my screen is the defendant in this matter, Ms. Freeney. Ms. Freeney, good morning to you.
Good morning.
Next on my screen is the plaintiff in this matter, Mr. Rivera. Mr. Rivera, good morning to you.
Good morning.
So I received a copy of your motion and I've read it. And Ms. Freeney, did you get a copy of that as well?
I did, yeah.
Okay. So Mr. Rivera, anything you want to add to it? And then we'll hear from Ms. Freeney.
So, I only have 2 things to say for that. They're both very quick. I just want whatever we're practicing in writing now, or for us to go back and follow the original court order that you gave us back in July, which I don't have a problem with either one. The second thing being, I do believe there's parent alienation being exercised.
That's a now become a very nebulous psychological term. I don't parental alienation is more than just somebody saying that your dad is no good. There's a whole litany to it. So it's something I don't, it's almost like somebody saying someone's schizophrenic. You got to be very careful when you throw those words around because they have a lot of different meanings. Does that make sense?
Yeah, and I was only saying that because on the 20th of this month, the defendant told me that she would participate in our daughter going to self-defense classes to beat up her other biological siblings.
I don't think that's why you go to self-defense classes, but all right. Miss Freeney, what say you?
I don't know what he's really talking about. I did talk to him about getting our daughter involved in self-defense classes or any type of like karate or something because we also have a CPS case open that I've been talking to a caseworker with about. And she's been coming home every single week with different bad bruises and knots and scratches on her face and
Do you
things
really
like that.
hang on a second? Do you really think that that he's standing around whenever he has parenting time and just beating up your child or somebody else over there is doing that? Is that what you
No,
think?
I absolutely don't think that it's him. I think that he just has a lot going on right now. He has a few different children and he lives in a very busy household. And I just think that he's neglecting watching them at what they're doing because they are the same age. I think his other daughter might be a little bit older than our daughter. But I know that she has come to me because I asked her where she gets it from. And I understand she's only 3, so she can only say so many things and she can only remember so much, you know. But she tells me all the time, Sissy did this to me, or, oh, me and Sissy fought, or things like that. And I've talked to him about it before, and his response to me was, tell CPS. So, I mean, that's what I have been doing. I've been taking pictures. I've been communicating with them. So I don't think that
that doesn't work anymore. See, all these the problem is not you, but it's all these cards have been previously played by different people, and everybody fly specs their child when they get home from parenting time. And if there's a cut or a bruise, they snap a picture, and I end up seeing it on a Friday morning, and CPS ends up seeing it, and CPS is not going to do anything about it. And that there's a certain modicum of trying to figure out how to avoid all this stuff rather than signing your daughter up for a self-defense class. I don't know if that's the best way to handle it, but what else do you think?
Besides that, I agree with him. We had been trying to file a motion to talk about our parenting time. We did agree upon a new schedule that we've been following and I think has been working pretty well for me. I can't speak for him, but for me, the schedule has been working really well where I had drop her off every Thursday. Oh, I'm sorry.
Okay. Here's what you do. This is very simple. You don't have to bring another motion. All you have to do is go to the Legal Assistance Center. They're on the 5th floor, and they have a document called a stipulation and order. If anybody's got a pen, they can write that down. And the stipulation and order is a document where you two put what your agreements are about parenting time. And then each of you sign it and it gets sent to me. And if I look at it and it looks good to me, which generally speaking, when two good parents figure this out, I usually sign on to it as well. If it looks good to me, I'll sign it. And then that's the order you follow. It should always be in writing because there's too many problems if it's not in writing. And if there's to the extent that there's things going on in your home, Mr. Rivera, where there's rough housing. Do I think for 1 minute you're sitting around punching your kid? No. Maybe she's playing with her stepsister, or however you would term her, and getting hurt. So to the extent that's going on, it's gotta, you can control that. Just step in and say no roughhousing. But also remember that if there are parenting time complaints, if you two are not following this new order, you got to start at the front of the court with complaints. But I will sign on to these new complaints. And it sounds like Ms. Freeney and Mr. Rivera that you two are in agreement, because he said, I'll sign either one. And you're saying, okay, this new agreement's working out. Put it in writing. Let's get it signed and let's move along. How's that?
Sounds great.
All right. Thank you both. Have a great weekend. Legal Assistance Center has the forms. They're on the 5th floor.
Thank you.
Thank you.
Thank you.
Next is number 18. Case number 1605013 DP, Strong versus Johnson.
All right. First on my screen is the plaintiff, Jada Strong. Ms. Strong, good morning.
Good morning.
Okay.
I'm sorry?
Sorry, give me 1 second.
Nah, that's not how it works, Mr. Johnson, but I think you're frozen. There you go. Can you hear me now?
Yep, I can hear you now.
Okay. And Antonio Johnson, the defendant, joins us. Mr. Johnson, good morning to you. So
Good morning.
I have reviewed your motion, Ms. Strong. Did you get a copy of that too, Mr. Johnson?
Yeah, I got a copy of it.
Okay. Anything you want to add to it, Ms. Strong, before we hear from Mr. Johnson?
No.
Okay. Apparently, the request is to relocate to Raleigh, North Carolina. Why you want to do that?
I have been looking into relocating out of Michigan for a few years. Obviously, it's not something that you just do in the blink of an eye. You have to kind of do your research and figure out where you'd like to be. I've been to Raleigh, North Carolina a few times. I've thoroughly enjoyed the culture there. Obviously, the weather's a lot different than in Michigan. Like I said, I've been doing my research in regard to the area. Stronger job market, higher paying salaries. I'm completing my degree in psychology. They have a strong growing industry within that field. So just a few different reasons as to why I chose that area.
Okay. And what would you, well, let me first ask you this. What is Mr. Johnson's parenting time pattern been?
So we don't have a current parenting time agreement set in stone by the friend of the court.
Okay.
Essentially, whenever he decides that he wants to spend time with the child, we attempt to make arrangements.
Okay. So the last uniform child support order that was entered says that he has 5 overnights a year. Is that accurate, or is it more?
Give or take. The last overnight that was recent was October 10th through the 12th. I can't say when the previous one was prior to that.
So as far as school conferences, you do all those things?
Correct.
Does Mr. Johnson do any of those things?
He has not been to a parent-teacher conference, no.
Doctor's visits?
I do those.
Dental visits?
I do those.
Right. What are you proposing then would be, if we did this, what would you propose Mr. Johnson's parenting parenting time would be?
Obviously with it being such a great distance, summers, holidays, school breaks, things of that sort, I'm open to in regard to some sort of scheduled time. I know that his work schedule is conflicting, so it would definitely have to permit that he would be available to spend the time, making sure he can cut that time out for the visitation.
Okay, Mr. Johnson, I'll give you the floor. Your thoughts, please.
For me personally, I don't mind her moving there, but my biggest issue is, yeah, I work a lot of hours, like consecutively. I'm actually on my 93rd day straight due to how much I pay in child support. And whenever my son decides he wants to come with me, I let him come. He gets whatever he wants when he's with me. I don't really see it being fair to her to take him from me that far right away due to the way I have to work. Like I just had to work and save my money to buy a home and everything else, so I can have things established to have more time with my child.
So what, when was the last time your support was looked at?
Last year actually, and I pay her a substantial amount of money every month.
Okay. All right.
To the point, like, I get one check to myself.
Okay. Ms. Strong, I'll give you the last word.
We just had a child support motion within the last year and a half. That child support motion was gone over because the original child support motion was set in stone back in 2016. It hadn't been reviewed in for many years. And at that time, the judge advised that child support orders are usually reviewed on a consistent basis for whatever reason.
3 years.
Every 3 years. It was well over 3 years before it was reviewed. And that was me filing a motion to have it reviewed. So in regard to, the child support order, yes, he does pay child support. I don't request any additional financial assistance when it comes to the child. In regard to whatever my son needs or asks for while he's with him, that's a given. He's within your care. You should be caring for him. But in regard to the amount of time that he does spend with him, it's not consistent and it's not a lot of time.
Okay.
But that's it.
All right. Well, first of all, it doesn't sound like the parenting time has been looked at for a while. And I think it's going to have to. The last custody order in this case was entered on December 20th of 2016. Plaintiff mother was granted physical custody, and since it was a paternity case, was awarded legal custody as well. Plaintiff mother wishes to relocate to Raleigh, North Carolina. Clearly, the established custodial environment is with the plaintiff in this matter. I mean, the child looks to her for really all the necessities of things like doctors, school, that type of thing. So I don't believe that Mr. Johnson has what's called an ECE or a established custodial environment. So there's two things I'm going to do. First thing is the law is pretty clear when someone has legal and physical custody and there's no established custodial environment. The court doesn't have much leeway in approving the move. That was set forth in Brecht v. Henry, 297 Michigan Appeal 732, a 2012 case. So I will grant the motion to change domicile, but I'm going to also refer the issue of parenting time to the Kent County Friend of the Court's office for an investigation and recommendation. Ms. Strong, are you currently working?
Yes.
Okay. The fee for that is $300, and that's going to be your responsibility because you're obviously the one moving. So they will get in touch with both of you, and they will try and come up with a game plan for, as you said, summers, holidays, something to take the place of what's going on now. Now, you, when you prepared this motion, they gave you an order regarding change of domicile, but it's blank. So I need you to go back to the Legal Assistance Center and fill that out. I'll do the order of reference for the parenting time, but you need to fill out the order regarding change of domicile. And you can do that at the Legal Assistance Center.
Okay.
So may I add something?
Yeah, absolutely.
Well, the time and being spent isn't necessarily just all me, because there's numerous times that I called for my son and she says he has other things going on. And when he's not with me, he's with my mother or my sister half the time.
Sure.
A part of my support system. So I don't understand. Let's just say I don't understand how could she just how could you say that the environment is the environment isn't what it's supposed to be.
No, that's not what I'm saying. See, the problem is when you represent yourself, this kind of stuff happens. That's absolutely not what I'm saying. I have to make a finding by law of what's called an established custodial environment. That's where your child naturally looks to for love, guidance, the necessities of life, doctor's appointments, school appointments, those types of things.
I
And
also pay for those also though.
I understand. And at that time, at this point, unfortunately, you do not have those types of things, probably because you're working a lot, and I don't fault you for that. But and I know you have a support system, and that's why I'm hoping when this case gets to the front of the court for parenting time, that they craft a remedy that would give you more consistent parenting time of a longer duration, rather than having to a day here, a day there. I'm hoping for a little bit more substance in that. And the front of the court will tell us what's going on. But I can't make you, just like I can't with a lot of people who represent themselves. These are complicated things, Mr. Johnson. And what I would suggest you do is go ask an attorney.
I understand that. The thing is, me had a conversation. I told her I was willing to do joint custody. He could just, because I've worked to get all these things established for him, and now that I have them established for him, she's trying to take them away. That don't make sense.
No, that's not true. I did not hear any of that. Actually, your relationship could get a little stronger when you have more consistent and longer parenting time. And I'm hoping that's the case. So, Ms. Strong, you're going to have to prepare that order. I will do the order of reference and make sure that the front of the court has all your correct info, because they don't forward mail. So make sure they're right on top of things. Okay. You both all set with me. Have a great weekend. We're adjourned.
Okay.
Yep, you do.
We have 21 A and B next. Case number 2412784 DM Wheeler versus Wheeler.
You all settled there, Ms. Wheeler?
Yes.
Okay. It looks like I have competing motions, which is always Interesting. The first motion is by Ms. Wheeler, and that's relief from judgment. Did you get a copy of that, Mr. Wheeler?
Yes, I did. I actually filed a reply too.
Okay. When did you file that?
It was the day after I received it, so it was,
Oh, I got it. Yeah, I do have it.
Yep.
Got it right here. Then you have also filed a motion relative to parenting time. Ms. Wheeler, did you get a copy of that?
I did.
Okay. Let's start with Ms. Wheeler's first. Motion for relief from judgment. Let me tell you what I know. On August 6th of this year, there was a pro confesso hearing scheduled, but it was adjourned until September 16 of 2025 with referee Kessler. The judgment of divorce was signed by referee Kessler on September 16 of 2025. Along with that is also a referee statement, which tells the parties there's a what's called 21-day objection period. When the judge did not receive any objections, the judge signed it, the judgment, which included all the addendums. So I guess my question to you, Mr. Wheeler, and I think you answered that in your response. You prepared a proof of service on August 20th that says you sent a copy of the proposed judgment to Ms. Wheeler. Is that true?
Yes, the only thing that changed between the two things was the parenting time agreement. That was the only change that was there.
Okay. But included all the addendums.
Correct.
Okay. So Michigan Court Rule 2.612 allows relief from judgment for such things as mistake, inadvertence, surprise, excusable neglect, or fraud. So I guess my question first, Ms. Wheeler, why didn't you object to any of this stuff going on?
I don't understand. I didn't have any of that information. None of that was sent to me from the last court hearing. I didn't get any of that paperwork.
Oh, because he, Mr. Wheeler, signed a verified proof of service that it was in fact sent to you. Did that come back in the mail, Mr. Wheeler?
No, that one did not come back. Are we talking about the first one I sent out, or it would have been the second
Yes.
one?
Well,
First one?
the first one or second one, either one of them.
The first one did not come back and got sent. The second one did get sent because the county clerk, when I went to get everything with them, took all the copies and wouldn't give it back, so I couldn't mail it to her.
Okay. But she has had that at least 14 days before you finalized your divorce.
Mm-mm.
Okay. Well, I know you say no. He says yes. But I've even, there's so many other questions on this thing. Because there's been so many opportunities to object and appear, and you didn't do any of that stuff. And I'm just trying to see why. Why would you not do that?
I've never received any of it.
Okay. All right. Mr. Wheeler, I got your motion relative to parenting time. Did you get a copy of that, Ms. Wheeler?
I did.
Okay. What's going on with parenting time, Mr. Wheeler?
Our daughter goes to school in the morning. My ex has an issue getting her there on time. She's currently missed 4 days since the start of the school year and had 7 tardies sent
No,
also.
that is wrong. I have the
Hang
paperwork.
on a second. Hang on. I think you might have missed the part, Ms. Wheeler, when I tried to tell everybody right at the beginning that you cannot interrupt people because it mutes out everybody's microphone. So I need you to just remain silent. I'll hear from Mr. Wheeler and then I'll hear from you. Okay?
Okay.
Go ahead.
And I have the dates they were missing, and I actually get the information from the parenting app that is linked to the school, so it gives me a calendar and what days and how many times she's missed or has been tardy.
All right.
And
Did the school voice concern? Did they say that this might cause her to be truant? Is it costing her? I mean, is the teachers saying, boy, but for this, she would be an A student, but because she's missing so much, she's not an A student. I mean, is there any of this stuff?
School did send text messages about that. One of them was like, hey, she's missed multiple days already, trying to see what was going on with it. And
okay. Go ahead, Miss Wheeler.
That is completely false. I have paperwork right here that she has missed absences of 3 days, and she's only had 4 tardies, and I've got the paperwork right in front of me.
Okay. Well,
and she's got good grades. She's above a 3.3 in her. She's exceeding expectations. She's proficient in mastery grade level content, approaching proficiency 2.5. Basic understanding, she has 2.0. And the only thing that she's struggling with is following directions.
Thank you.
Mm-hmm.
Well, I am going to, at this time, deny both motions. I need more than that, Mr. Wheeler, before I ever entertain doing something.
I can go get go make another motion, but have attached the.
I need a lot. I'm not telling you how to do your business. Okay. I would never do that. But I'm telling you that you need a lot more than just a 1-paragraph statement for me to do anything as far as parenting time when it involves school. You might want to start with teachers. You might want to start with the attendance officer, all those things. And I might consider it. But I'm denying the motions, both of them right now. So you're both all set with me. The judgment is going to stay, and I'm not changing anything. But if you want to go ahead and do some due diligence on this, Mr. Wheeler, I'll entertain you bringing it back. Okay? You both are all set. Thank you.
Yeah, thank you.
Let's move to number 1. And that is case number 1703974 DS Block versus Wheeler.
All right. First on my screen, MLB must stand for Monica Lynn Block.
Yeah.
Good morning. Can you hear me okay?
Okay, yes.
Okay. And you are David Wheeler?
Yes, sir.
All right. This is your motion to have the court order that I order an autism test. Am I understanding that right?
Yes. Yes.
Okay. Monica, what's your thought process with that? Is it indicated? I mean, has your doctors?
I don't mind it. I brought him to the doctor and they thought he was an exceptional student, like more of the, his genius gives him his behavior problems. He reads at a 5th grade level. He's 8 years old, but he will get social problems somewhat due to being advanced.
Okay. Well, have you ever, I guess, discussed it with either the school or a
Yes, I
doctor?
discussed it with.
Hang on. Oh, see, you missed the lecture too. You have to wait for my question before you can jump in. I know there's a lot you want to tell me, but wait till I get the question out, please. Okay.
Yeah.
Have you spoken with doctors, teachers, therapists, any other people who would have day-to-day contact with your child to see if a test is even necessary?
Yes, I've had conversations with his primary physician and his teachers, his IEP team, and his social workers at school. He has a counselor at school who are also working with him. I went over yesterday a new BIP plan with the school that seemed like it really helped him. For 7 days, he had perfect score, like was doing great, but he sometimes gets derailed off his plan.
Okay.
If he gets overwhelmed.
Does any of these professionals that he sees, have they broached the subject of possible autism?
Not as much this year. He has not, at his age, he doesn't have as many of those problems. And a lot of them on the school record say that, at his age, he's getting, more adverse to doing these things and doesn't seem to have problems with them this year.
Okay. Yeah, are you just dead set against him having that evaluation?
No, I'm fine with him having autism. I just want him to have the proper evaluation. I do think he has emotional, might need a therapist and more for the emotional side of things. And he could be at the same level as any other student there, especially he's very smart and he does read at two or three grade levels in advance.
Okay. So, you don't have a problem taking him to go get an autism test?
Yeah, and
I think it's called an evaluation.
I have looked into it, and the only place I can do that is the
What happened? Where'd you go?
oh, sorry. The only place I can do that is through the Holland Community Health Center. And I've tried going through there, but they didn't think over the phone his issues were severe enough for their services when I did call.
Okay. Mr. Wheeler.
Yes, sir.
There's not a whole lot I can do because you don't have legal custody.
And that's what I started this for in the first place. 50-50 legal was what I started this whole thing for in the first place. And everybody wants to just talk about custody and everything else. They don't want to talk about 50-50 legal. I'm trying to get my son help.
Well, you're not listening to me, first of all. You don't, the last custody order was dated June 8 of 2017. And the mother, Ms. Block, was granted physical custody via a consent judgment of support. And as such, she is granted legal custody as well. And the reason I'm saying that is because having legal custody has nothing to do with where a child lives. Legal custody is the ability to participate in major decisions affecting your child's health, safety, education, or welfare, like a autism test. And you don't have that at this point. You can petition the court to consider legal custody for you, and you wouldn't even have to show a change of circumstance. But right now you don't have it. And since you don't have legal custody, you don't get to participate in these major decisions. So I have to rely on the parent that does, and that's Ms. Block. So options. One, you could file your own motion to request that the court grant you legal custody of your child. And that's, you wouldn't even have to show a change of circumstances pursuant to the case of Sims versus Verbrugge. You could do that. And then that way you can get copies of all records and things like that, because that's probably what you're going to need to come back in front of me. I'm going to need more records from physicians, from teachers, from counselors, from therapists, from whomever, that in autism evaluation is necessary, because I think you might be onto something, but it has to be done the legal way. So I can't grant your motion.
I'll see that. Go ahead.
But you can, like I said, you got some options, and you might want to see if you can speak with an attorney about these things, because they will help you out, get you the right things in the right place in the right order, and go from there. That's what I would do.
Well, my problems, sir, is that's the first order I put before you guys was asking 50/50 legal, because that's what I wanted to have, because that's what I was told I needed to have in order to get this done. And nobody wants to talk about custody. They just want to talk about visitation. They want to talk about everything else besides custody. And that's the first step that I did in the first place.
I just talked to you about it. I just talked to you right now about it.
No, you talked about you talked to me about it the first time too. You were there the first time.
I'm with you. I talked to you about it. Now you got to file it. File a motion.
I did file it. That's what I filed the first time.
Are we done here, Mr. Wheeler?
Are
we done? Are we done?
We can be done.
Okay. Okay. So I've told you I respectfully will deny your motion. I would meet with an attorney and see if they can't get you on the right path. Okay.
Yep.
You're all set. Thank you both very much. We're adjourned.
Next is going to be number 22. And that is case number 1509211 DP Williams versus Smith.
Okay, I have first person in front of me is the defendant, Frederick Smith. Mr. Smith, good morning.
Good morning, y'all.
And the next person, I don't know, something's on your camera, Miss Williams, because I can't hear. I probably can hear you, but I can't see you.
Okay, let me figure this out. I don't know.
Well, I don't necessarily need it. You can just keep it off as long as I can hear you. Okay?
Okay. Yes.
All right. Because otherwise that's going to create all kinds of things. So, Mr. Smith, I read your motion regarding child support. Let me ask you, Ms. Williams, if you got a copy of Mr. Smith's motion.
Yes, I did.
Okay. I read it, Mr. Smith. Let me tell you what I know, and then I'll hear from you. So on January 19 of 2024, this court ordered the front of the court to review child support, which was last entered by a uniform child support order dated September 27, 2023, in the amount of $551 per month. The front of the court completed their new review and recommended no change. And actually, it went up $40. But see, if it doesn't affect it $50 up or down, they will not change support. So they completed their review and there was no change. Now, I've had quite a few cases today that, and I can tell everybody this, that in a perfect world, everybody would take into account everybody's bills. Okay, they would say, okay, this is how much he pays for this. This is how much he pays for this, and but they don't, because the laws in this state basically say all your other bills are secondary to child support. And I didn't write the law, obviously, but I have to enforce it. So I can't grant your motion to change support unless there's been a substantial change of circumstance. If your income has gone up, if you've had another, or down, if you've had another child, if the other side's income has gone up or down, those are what they call substantial changes of circumstance. Otherwise, you have to wait until 2027 before you can do it on your own. But like I said, if there's been a substantial change of your circumstances, not counting the bills, I can't do anything about. But if it has to do with your income, the amount of overnights, other children, that's type of stuff, I might be able to get the friend of the court to do something else. But I don't see any of those things in your motion. All it says is I need to pay my bills, and unfortunately, I
No,
agree with you 100. Hang on, I agree with you 100%. But there's not much I can do about people's bills. Go ahead.
no, listen. I understand, that my child being there, that $500, due to bills and all that, it probably won't even scratch what her bills is, knowing her. Only thing I'm asking is to reduce not touching my little check, my hearse. I'm getting both checks being taken out. My big job can take care of my whole child support. Only thing I'm asking is just not touch my little check, hers. I don't care about not paying the money. She deserved that. I'm just asking to not touch the little check.
Okay. So I'll tell you what the law is on that. I cannot force you, nobody can, to work two jobs. Can't ever force somebody to do that. Just like I can't force anybody to work overtime. I can't do that either. All I can do is the 40-hour main job. The problem is when you do that, when you do work overtime or you do have a second job, they count it as income for child support. And I don't know, there's not a way I can say, don't touch that. I wish I could, but they can't force you to work two jobs. But if you do, they have to count it. Okay, that's unfortunate, but that's how I wish I could do whatever I wanted to here, because I'd have a lot more happier people today than I do already. But Ms. Williams, what are your thoughts?
Well, I agree with the child support that's now. I mean, I could ask for more, but I guess what he's paying is good enough right now. But I do want to know why he never asked for parenting time. He hasn't seen her in over 2 years.
Yeah,
And
I know
before that,
that's
it's longer than that.
and I know that's on your mind, but unfortunately, all I can cover is the motion relative to child support. I can't cover the parenting time aspect because that's not in front of me. But
Okay.
if somebody brought a motion regarding parenting time, I can't make people do or be great mothers or great fathers or do this, anything. I can't. I wish I could. But because parenting time actually is one way that parties can reduce their child support, because the more overnights you have a child, the less stress it is on you. And because you wouldn't have to, you know, the theory is anyway, that if somebody
I'm
has
I'm I'm with
overnight
I'm with I'm with that. I'm with that. Now that I'm stable, I have my own apartment. I'm with that. You know what I'm saying? I'm with to
okay,
come to agreement with the overnights. So yeah,
you want
she
to,
right.
what you have to do, well, hang on. We have to do this right, folks. You can't do it just haphazardly. So the way you do that is you would have to file a motion to review parenting time. And if you do, I will promise you, I'll take a look at it. And if you and Miss Williams come to an agreement on parenting time and it sounds good to me, I'll enter it into an order. If the parties need some help, I would send it to the front of the court and let them make a recommendation to me about parenting time. But I can only do what I got in front of me, and that's child support. Okay. So
Yes.
I can respectfully deny your motion, but I really appreciate meeting both of you. I wish you the best. I hope this parenting time situation gets resolved, but you can both sign off. We're adjourned. Thank you.
Thank you.
Next is number 24, and that is case number 1807980 DP, Gardner versus Nanninga.
All right. Both we have all met before, and Mr. Nanninga is first on my screen. Good morning, Mr. Nanninga.
Good morning.
And next is Miss Gardner. Miss Gardner, good morning.
Good morning.
I've read this motion, and in essence, I've heard this now. This is my third time since February. And everybody's going to say it's not happening. Other people are going to say it's happening. So I've read everything. Anything you want to add, Ms. Gardner?
Yeah, the fact that I'm having to bring her to the hospital continuously because of situations like this, it's inhibiting my ability to actually stay at work. I had to leave work that Friday to go take her to the hospital, which, I mean, as her mother, yes, I should. I'm glad that my job was allowing me to do that, but that cuts into my money as well. And he knows that she has these allergies and continuously allows his mom to bring her over to her house, causing these issues to continuously happen.
Okay. Mr. Nanninga, you got a copy of this motion, did you not?
Yes, I did.
Because I got a very detailed response, but not from you, but from your mother. Did you get that, Ms. Gardner?
No, I did not.
You didn't get a copy of this? Is pretty long.
No.
It had pictures and all this stuff in it. Okay.
No, I have not.
All right. Well, do you know, Mr. Nanninga, if your mother sent this to Miss Gardner too?
Yes, it was sent out on Tuesday at 3:05 p.m.
This Tuesday or last Tuesday? I'm sorry.
This Tuesday, because I didn't get the motion till last Friday.
Right. And did you, Ms. Gardner, did you not, nothing came in the mail?
No.
Did it come back to
I can
you?
check my mail right now real quick.
You can check the mail right now, but I'm a big stickler on everybody having everybody's stuff before I hear anything. And I don't like the fact that Ms. Gardner doesn't have what was written by your mom. that has to be remedied. So what I'm going to do is, Ms. Gardner, you can renotice this motion, postpone it, give you a chance, Mr. Nanniga, to send your mother's response to Ms. Gardner. And then the next time we reconvene, we'll all have everything and put all our cards on the table. Because I will tell you this right now, I have some possible solutions, and one of them involves appointing a guardian ad litem for your child, and that's going to cost $5,000, and that will run $2,500 a piece for you and Mr. Nanniga. That's one possibility. So I want you to read what Grandma says, and then renotice this out. You won't have to pay another fee. And I will see everybody when they come back, and everybody has everything else, and could use some more. Yes, I would like a letter from physician as to what exactly this is. Because I have found that these allergy things could be dogs, cats, other animals, dust, mites, all kinds of stuff. And we may have to rule out some of that stuff first, but I want to wait to see what you have to say about the response from Mr. Nanniga's mother. Okay. So you know what to do?
Yeah.
Okay. But I'm just telling you both, if you can't come up with a logical explanation to this, I'm going to have to appoint a third-party attorney to look out for your daughter, and that's going to cost you both a lot of money. And I'm hoping to avoid
why would it be on me when I'm the one trying to keep her from being in these situations?
Because the attorney only works for me and only represents your daughter, and it's on both of you. She's both your daughter, so you both pay it. But I'm not there yet. You wait till you get this response, and if you feel the need to bring it back after you get this response, I'll listen to it, and we'll see. But I'm just telling you that I have to break this log jam, because I'm not going to keep going through this. This is now the third motion. February, August, now November. Third motion. Okay, so something's going on. But if people are looking for me to prohibit people from overnight parenting time, I generally don't do that unless I have something from a doctor that says, hey, look, this is all happening at this house and the child needs to stay away from that. I'm also a little concerned when I read an allegation that grandma has told the child not to say anything, because that's problematic too. But that's what the attorney does. But yeah, Ms. Gardner, if this is going to cost you and Mr. Nanniga money, okay? But I'm not there yet. I got to see what's going on, and I want some more information. So renotice this when you get this. Let Mr. Nanniga know when you get a copy of his mother's statement, because I want you to read that in full. Okay?
Okay.
All right. Thank you both.
We will move to number 26 next. Case number 1509590 DM, Herring versus Herring.
All right. First on my screen is Adam Herring. Mr. Herring, good morning.
Good morning.
Is Carrie Herring on the call?
She was present, but she is no longer with us.
Okay. I think her name is Frick now, isn't it? Yeah. So the first question I have, Mr. Herring, is who helped you prepare this motion?
My wife?
Okay. Is your wife an attorney?
No.
Because she violated the court rules. Okay. And that means
Okay.
you have violated the court rules too.
Okay.
So, and the reason I'm pointing this out is this. Because from what I've read in here, there has to be something done about this. But if you are going to, and I believe me, it's going to get more complicated from here. Okay. And if you are preparing these kind of motions and they're running afoul of the court rules, it might be a time to say, you know what? It may be time to bite the bullet and get an attorney to help you, because it's only going to get more complicated from this point forward. Because from what I read in here, there's some disturbing things. The last custody and parenting time order was the party's judgment of divorce dated May 3rd of 2016. The parties were awarded joint legal custody with physical custody to plaintiff mother. I read these allegations in here. Anything else you want to add to them?
No, sir.
They're disturbing. I will tell you that. The case in Michigan relative to custody is Vodvarka versus Grassmeyer, 259 Michigan Appeal 499, a 2004 case. And what that says is I can't jump back into your business unless I have what's called proper cause or change of circumstances to do so. The allegations you have made include multiple moves, academic issues, financial constraints, CPS involvement. I think you've met the threshold to open this back up. I find the appropriate best interest factors are MCL 722.23B, C, especially D, E, H, all those things. So I can't change custody without a evidentiary hearing. And prior to an evidentiary hearing, I refer these issues to the friend of the court for a complete investigation and recommendation. So I'm going to grant your motion to reopen custody. I don't like doing that, especially with older children. I mean, you got a 15-year-old and an 11-year-old, but some of the things in here are really disturbing to me. I'm not, there's two sides to every story, but still. So I'm going to send it to the friend of the court for an investigation and recommendation on all issues. The fee for that will be your responsibility. You should also make sure that you have a current address with the friend of the court because they don't forward mail. And if I see your ex was here, but is not here anymore. And if you see her, you can tell her that's what I did, and she needs to do the same thing. Like I said, in the future, the court rule is MCR 2.119. That has the motion practice, and you can't include all the things you included like you included them. That's the problem.
Okay.
But I think, like I said, I always tell people that are representing themselves, I give them a lot of credit because I'm an attorney and I've been doing this for a long time. I wouldn't even represent myself. So I give a lot of credit to people, and I know attorneys are expensive, but this is your kids you're talking about here.
Yeah, I can get an attorney. That's not a problem.
It's real important that you follow the guidelines to the hilt, and but you may make that decision after you've met with the friend of the court. You may make it before. But I mean, asking an attorney if you need an attorney is like asking a car salesman if you need a car, right? I'm
Right.
always going to recommend that, but I know everybody's got their own circumstances, but I'm going to grant your motion. I will do the order of reference today, and you are all set with me. Hopefully the friend of the court will get with you in the next 7 to 10 days. Okay.
Okay.
You're all set. Thank you very much. Have a good weekend, and thank your wife for giving you a hand.
Thank you, sir. You too.
You bet.
Bye.
Next is number 8 on our list, case number 1508124 DP, Kite versus Carswell.
All right. First on my screen, the defendant, Mohammed Carswell. Mr. Carswell, good morning.
Good morning, Your Honor.
And next on my screen is Larissa Kite, the plaintiff in this matter. Ms. Kite, good morning.
Good morning.
I have read your motion, Mr. Carswell. Did you get a copy of that as well, Ms. Kite?
Yes, I did, Your Honor.
Okay. Then anything you want to add to that, Mr. Carswell, before we hear from Ms. Kite?
No.
Okay. Ms. Kite, you read Mr. Carswell's motion. What is your response?
I would like to point out that Mohammed has canceled appointments recently with Journey. You could see that in the report, Journey's provided that there was a NA put down for canceled visits, but you could see there was a gap between 9/18 and week of 10/01/25. Also, there was a canceled visit on 10/14/25 for the date of 10/15/25, which was the date the Journey read in the report.
Okay.
Also, well, yeah, I would like to add Mohammed has stopped paying child support. From my understanding, well,
that's not in front of me.
There is a point for this. From my understanding, he lost his job. He's over $17,000 behind. I've never raised child support. I'm not asking much, but the safety and the well-being of my child is more important. My concern is if Mohammed can afford $60 a week to visit his child, how is he going to provide for him for 3 days? That is my concern.
Well, it's all good questions, but obviously one doesn't necessarily have to do with the other. But I will tell you this: I think the Journey's report is. I agree with you, Ms. Kite. There is a gap. There are some unanswered questions, but the Journey's report at least gives me some encouragement that perhaps things have gotten better, but we don't know. This motion was originally noticed from 10/10 of 2025. And I've heard a motion, or one's been filed on 5/9 of 2025. The last parenting time order was this court's order of August 21, 2025, or 78 days ago. Not very long. Parenting time, 1 hour per week at Journeys. Defendant pays all the fees. Obviously, if father fails to contact Journeys, then parenting time suspended. And any other times the parties agree. So it looks like Journeys was contacted. What's somewhat interesting to me is that the friend of the court sent out a recommendation on July 23rd of this year with a 21-day objection period, and that ran up on August 13th, and nobody objected to it. Is there a reason for that, Mr. Carswell?
Your Honor, I haven't seen my son in it's been a while, and I just got back into better health, and I just got my own place to be able to provide. Currently, I am transitioning through life, and uh, what I owe will be paid, and I currently just can't afford to do journeys and feed myself at the same time. It's just not feasible.
Well, isn't Journeys ran out of money for the grant, and they got some more back. So I can do a re-referral for Journeys and have the grant pay some of that money for you.
That will be great, but I was just there Wednesday, and they said once again that all of the funding for 25 is over.
They haven't said that to me. We have a different pot of money. Ours is by the in conjunction with the friend of the court. I'm going to try that first, see if we can't get you some relief in that respect, because I got two things going on. I got, on the one hand, it sounds like you're making positive changes. The Journeys report was positive. But on the other hand, I've got a mother who is concerned, and an order that the concern was enough that the judge put it in an order. So I'm going to do a re-referral to Journeys with the grant in there, and let's see if that helps out a little bit. Okay.
I understand that, Your Honor. Is it possible?
Baby steps here at the start.
Is it possible that we can have a future date to where I'm not going to Journeys?
Oh yeah, I mean, Journeys, let me tell you both this. Journeys is not meant as a permanent solution. It's never meant that way. It's only a temporary solution while things get figured out. Okay. So at some point in time, Journeys is going to end. The question is going to become is what then? And that's why I'm just wondering what the friend of the court was intimating in their latest recommendation. So it may have to go back there. But yeah, it's not, I can't give you a date that it's going to automatically stop. All I can tell you is that it's not a permanent solution. There may be other ways to do this. Some of the other ways are people have agreed to other people in the community that could maybe supervise things. Some people say, okay, let's have parenting time at grandma's, or, you know, in the public with somebody who everybody trusts. There's all kinds of possibilities. But right now, I want to get you back on track at Journeys, and then we'll explore these other options at a later date. Okay.
I understand that. So how would I go about figuring to do something outside of Journeys?
Well, you and Miss Kite can always talk. There's nothing preventing you two from, and if you have issues with one another, it's too bad, because you're parents to a wonderful kid. But if you can't, then write letters and say, okay, this is what I'm proposing. I'm proposing we do Journeys for a couple more weeks, and then after that, I can have fill in the blank do the supervised parenting time for a while, and let's see how that goes. I mean, it's a process. That's all I'm telling you, is that it's never going to be fast enough for you. I understand. And it's going to be too fast for Miss Kite all the time. And that's where the trade-off gets in. But we do what we can. We hope that we can come up with something, but the parties can talk, because Journeys is not going to last forever. I'm telling you both that way. It's not meant to. It's a gap while people, for whatever reason, if sometimes it's drug rehab, sometimes it's alcohol rehab, sometimes it's transitioning life, getting their stuff together, that kind of thing. And once they've done that, then we need to talk about where it goes from there. So let's work baby steps first, and we will start with a re-referral to Journeys and get you some relief that way. And hopefully you can start the child support going back. I know Miss Kite would be real mindful of that. And let's see where we go. Okay.
Your Honor, she and we don't speak to each other. All of her
That's
information.
too bad. Guess what? You're going to have to learn to, aren't you?
Her information is confidential. I don't know how to get in contact with her.
Easily. You take a letter and you bring it to the front of the court. They then will forward it to her. That's by law. They have to do that. And then she can do the same as far as to you. So
I appreciate it.
There's always ways to do this. Okay. You guys just got to think a little bit more out the box. All right.
Yeah, Your Honor, especially because of where I am at right now in life. I am transitioning to a much better place than I ever was.
You don't have to convince me of this. I see it. And I read it. You have to convince Miss Kite of this. And she needs to see it. Trust is a tough thing. And you got to win it back. Okay. But when trust is lost, you have to be given the opportunity to win it back. And if she is being unreasonable and just won't pay any attention to trying to win back that trust, then I intervene. Okay. Then I make the decisions. But I think right now we're going to start there. All right.
Sounds good.
All right. Thank you both very much.
Thank you, Your Honor.
Have a good weekend.
You as well.
Likewise.
Thank you.
Next is number 27, case number 2500154DO, Copen versus Copen.
All right. You are Mohammed Copen?
Yes. Good morning, Mrs. Johanna.
Good morning to you. And
excuse me, you have interpreter Boston in English.
Not here. Do you need one?
Then you have much better. I know very good speak and know very good understand English. Thank you so much.
Well, here's what we're going to have to do. I'm going to have to postpone this for an interpreter. Okay.
Okay.
So you have to renotice this, and I will have an interpreter. What kind of interpreter?
Bosnia.
Okay. Then I will note that on the file. All right.
And I still hold the now.
No, we're not going to do anything today because it's not going to make a lot of sense.
I have one question for you.
Well, I don't want to answer. I see Miss Copen in there too. Can you hear me, Miss Copen? Yeah, I'm not getting anywhere there.
Hello?
Yeah, can you hear me?
Hello?
Hello?
I am here.
I see that. Do you need an interpreter as well?
Yes.
Okay, then I'm postponing this hearing, and when Mohammed refiles this, he's going to have to ask for a Bosnian interpreter. Otherwise, they won't automatically just give you one.
Thank you.
All right. You're all set. You both can sign off, and we'll hear this at a later date.
Next is number 2, case number 1910649 DM, Calvert versus Calvert.
All right, first on my screen is Amber Calvert. Miss Calvert, good morning.
Good morning, Your Honor.
Well, I'm sorry, good afternoon.
Afternoon, it is afternoon.
And is Darius Calvert on the call? I don't see Darius at all. It says on here, Amber, that on October 27 of this year, you sent a copy of this motion to him, first class mail on 10/27. Is that true?
Yes, I did.
Okay. And did it
It's no
come back?
no, I share the phone. I go
Hang on a
here for share
second.
this phone.
There we go. Sorry about that. And you sent it to his last known address?
Yes,
And it didn't come back in the mail or anything like that?
it did not.
Okay. And has he acknowledged that that you sent it? Has he responded to you in any way?
No, we have a PPO in place at this time.
Okay, so if he would respond to you, that would probably be a violation of the PPO, right? So I read your motion. The last parenting time order was dated March 9 of this of 2023, which provides it's kind of an interesting rotation that the parties have. It's on week 1, it goes Friday at 5 until Saturday. Week 2, Friday at 5 until Sunday, and then it rotates that way. What I've read in here, I have some questions on, obviously. There's allegations of domestic violence, and I take those very seriously. So was someone charged in that incident? Because I know it didn't involve you versus him. I think it was his present partner, or is that what I'm reading?
It was the 3 of us.
Okay,
but no,
all 3 of you.
yeah,
Okay.
but no, because of the circumstances, they tried to press charges towards him, but everything was dropped. So no.
Why was everything dropped?
Well, unfortunately, my camera cut off. It was caught on my Ring camera, and you can't see anything beyond the initial contact that we had.
What's his current parenting time? Does he exercise what this is?
Okay, so I filed a motion back in 23 requesting that we put something in place because we did not have anything,
Right.
and there was no structure. He did not show up to mediation, so the mediator agreed that what we had in place at the time, which was just picking up and dropping off at my home, the weekends worked because there were truancy issues that were brought from the school at the time, because when he got them during the week, he did not take them to school. So the mediator suggested that it was in the best interest for them to only go on the weekends. So
yeah. So I appreciate the history lesson. Now fast forward me into today's world. What is his current schedule? I mean, is he abiding by this?
He recently, in the last few months, because he has a new girlfriend, she is holding him to that, and he has been getting them only on the weekend. But I want to clarify this, Your Honor. He is only getting my youngest 2. The oldest 2, and I pointed that out in my statement, he is causing so much conflict between them, and it's really unfortunate. So to answer your question, he is only getting the younger 2 on the weekends.
Okay. And give me some ages here.
Okay.
How old is DDC?
16.
And AAC?
14.
And DEC?
9.
and SJC?
8.
Okay, so you got 2 teenagers and 2.
Yes.
They're not toddlers, but they're young kids.
Elementary.
Okay, and what I guess what you're asking me to do is to suspend his parenting time. Is that what you're asking I do?
Yes.
Okay. See, that becomes problematic. The reason why is this. I'll try and see if I can explain it adequately to you. Before I can suspend someone's parenting time, I have to have what's called clear and convincing evidence that parenting time would be dangerous to the kids. Okay. That's found in Michigan Compiled Law 722.27A3. So I need clear and convincing evidence. And the problem is clear and convincing evidence is evidence that produces, in my mind, a firm belief or conviction as to the truth of all these allegations. And before the only thing I have in front of me at this point are allegations of domestic violence, and those allegations are not supported by any criminal matter. So I'm kind of
I understand.
I'm stuck with that. What I can do, because I think you have given me enough pursuant to Shade versus Wright, which is the parenting time case that allows me to stick my nose into parenting time, because one of the issues is domestic violence. And by all accounts, it's not that I don't believe you. It's just that when we have to support this stuff, it becomes difficult. So I don't have enough to support suspending his parenting time, but I think I have enough to send it to the friend of the court for them to review parenting time again. That I think I have, and I will. Are you currently working at all, Amber?
Yes. Yes.
Okay, where do you work?
Priority Health.
Okay, do you get any, how's his child support going? Is he paying regularly?
No, he just was in contempt of court for it
All right.
a few weeks ago.
So I'm going to send it to the friend of the court for a parenting time investigation, and I'm going to waive the fees. Okay, so you don't have to pay any fees, because I don't like trying to, if he's not paying child support, then I'm not going to hook those up for you. So we'll take another look at things, and if they think that I need to do something, they'll make a recommendation to me. That's probably the best I can get you today. Okay.
I understand. I do have one question. Is this in regard to the text messages he sent my the oldest two as well? He said that they're dead.
They're gonna do everything. They're gonna review parenting time for all 4 kids.
Okay.
And you know, there's one thing I got to tell you, and I wish I could fix this. I can't make someone a good parent. Okay, a court could never make you a good mother. You are one already. I can't make him a good father, no matter how much I try. So it's very difficult. to do that. But I can, like I said, get you back to the front of the court, and they can explore some of these things.
Okay.
Okay.
Okay. Right. So one last question. I'm sorry. In the meantime, with the PPO, am I still held to the current parenting time arrangement?
There has to be some intermediary or some provision for that. So what you may want to do is, I take it the PPO was in front of Judge Gottlieb.
Yes.
Okay, you may have to file a motion to amend the PPO to somehow figure out how maybe somebody else can help you with the parenting time stuff. Front of the court might also be able to help you.
Okay. Okay.
All right. Wish you the best. I'll do that order today, okay?
Okay, and then what do I do from there? Do I wait for front of the court to reach out to me?
Wait for the front of the court and make sure they have your correct info, address, contact info, and they will get in touch with you.
Okay, thank you.
Okay, you bet. Good luck to you, Amber.
Thank you.
You bet.
Last but not least, we have number 4, case number 2301695 DC Guerrero Martinez versus Chavez.
All right. It's always the one that files the motion that shows up. I can't figure out why that is, but you are, it says Chris down there. Can I call you Crystal? Is that okay?
Yeah, that's my legal name, Crystal. I go by Chris though.
Okay, Chris.
Crystal.
Can I call you that? Is that okay? All right. So it says here that you sent a copy of your motion to Mr. Chavez on October 10 of 2025. Is that true?
Yes.
Okay. And did it come back in the mail?
Like, did I receive anything back in the mail?
I mean, did it come back as he doesn't live here anymore or that kind of
Nope,
stuff?
I didn't return anything, so I'm pretty sure that means he received it.
Okay. He mentioned anything to you?
Nope.
Okay. So from my understanding, this involves your 5-year-old child, and the last parenting time order was this court's default judgment of support dated October 13 of 2023. It awarded you sole legal and physical custody, with defendant's parenting time being alternate weekends from Saturday at 9 until Monday. But as with all young kids, they get older, and apparently the problem is now that you would like the parenting time to, instead of being Saturday to Monday, you're asking for Friday at 6 to Sunday at 6, right?
Yes, and that's what you told me when I spoke to you last time I saw you, and I took your advice and I spoke to him about it and he agreed with it as well.
Okay. Then I'm going to grant your motion. Here's what you need to do. You need to go at some point to the Legal Assistance Center. They're on the 5th floor of this courthouse. They're going to show you how to prepare an order. And the order will change the support or change the parenting time. You're going to write in there and they'll show you what to write. It's going to change the parenting time from Saturday at 9 until Monday at 1 to be from Friday at 6 to Sunday at 6. Okay.
Okay, I thought that's what I'm sorry. I thought that's what I did because I have a copy where I changed it from Friday, the motion, and
No,
I sent him a copy.
You filed a motion. That's
Oh, so I need to go and file an
motion is a
order.
request. I have to either deny it or grant it, and I'm granting it. So now you have to prepare an order granting it, and you have to do that at the Legal Assistance Center. Same place, 5th floor.
Okay, prepare an order. Okay.
Okay.
Thank you so much.
Thank you for your patience. You're all set.
Thank you.
Bye-bye.